May I please, Your Lordship.
Yes.
Lordship, I beg to mention item number 4, Lordship. Lordship, this matter has become infractious, Lordship. Kindly, I may be allowed to withdraw this matter.
You're for the appellant.
Appellant, Lordship.
Your good name, please.
D. Lona.
And who's for the other side? Mr. Tagong is there. T. Tagong.
T. Tagum.
You are Mr. T. Tagong.
No, I'm.
You're on his behalf.
Yeah, on behalf.
They say that infractious. Okay. Mr. D. Lona, learned counsel for the appellant, submits that the writ appeal has become infructuous, and therefore ways that the same may be disposed of as infructuous. So, Mr.
R. Koyu.
R. Koyu, learned counsel, appears on behalf of Mr. T. Tagu and submits that he has no objection to the appeal. In view of above, the writ appeal stands disposed of as infructuous.
Lordship, I beg to mention item number 10. With the consent from other party.
Yes.
This matter we fixed on 20.
On 20?
Yes.
Why? You are.
My lord, I got a appellant.
So,
my lord, I have no objection. His senior is out of station in home, and let the matter be, my lord, keep on 20 man.
Okay. Who's the conducting counsel?
T. Tagum. I'm on behalf of T. Tagum. He's steering counsel for.
Out of station?
No, he's here. He's not out of his station.
Alright.
He's here, but because of due to personal difficulty.
Standing counsel, Education Department. Okay, Mr. T. Tagum, learned Standing Counsel, Education Department, appearing for the respondents, is said to have some personal difficulties to appear before the court today. Stop on a prayer on his behalf and not objected to by the other side. This is the matter on 20th of March, 2025.
Much. All right.
Yeah, Your Lordship. Your Lordship, I beg to mention item number 7. I'm for the petitioner and
This is an appeal. This is an appeal. That means you are an appellant, not petitioner. Yes.
Conducting counsel for this matter is R. Mishra, Your Lordship.
Who?
R. Mishra.
R. Mishra.
Yes, Your Lordship.
Conducting counsel on behalf who? For the appellant?
Yes, Lordship.
His name is not here.
Yes, firstly, his name is not there, but he is the conducting counsel for this matter, Your Lordship.
R. Mishra.
Yes, Lordship.
You are sure?
Yes, Lordship.
So what do you want?
Due to some unfortunate event, he's not been able to be here, Lordship. So matter may be listed after 3 weeks. Lordship.
What about the other side?
Lordship, I'm from the respondent number 2, Lordship.
Okay, no objection. Any objection? Any objection?
No objection, Your Lordship.
Mr. R. Mishra, learned counsel, who is said to be the conducting counsel, is said to have some personal difficulties to appear before the court today. On a prayer made on his behalf and not objected to by the other side, the matter stands adjourned for 3 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, I would like to mention item number 8, Your Lordship, on behalf of NJ Das, Your Lordship, counsel for the appellant, Your Lordship.
What happened to him now?
Yes, Your Lordship, he is an outstation lawyer, Your Lordship. He could not come today, Your Lordship, due to some personal difficulty, Your Lordship.
He's from outstation.
Yes, Your Lordship.
But there are other counsels here. Mr. M. Karbak, P. Mahanta, P. K. Das.
Your Lordship, he is the conducting counsel here, Your Lordship.
So,
Your Lordship, I have taken consent from that party also, Your Lordship. Matter may be listed after 3 weeks, Your Lordship.
3 weeks.
Yes.
Okay. Mr. N.J. Das, learned conducting counsel, is said to have some personal difficulties to appear before the court today. on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for 3 weeks.
Highly your lordship.
Item number 9 is connected.
Yes,
Item number 9, my lord.
yes,
I'm amicus. Item number 9, my lord.
yes, item 9, what about?
Yes, my lord. So that is connected matter, my lord. It may be taken.
Connected?
Yes, my lord.
Who's there in item 9?
Item 9, my lord, I'm both.
You are the appellant,
Yes, my lord, amicus.
amicus?
Yes, my
Okay, why is it clubbed together?
My lord, it's arising out of same FIR.
Mhm.
Same FIR. Same
FIR.
judgment.
So, it will come after 3 weeks?
My lord.
Oh, you want it to be detached?
No, my lord, let it
Okay.
become after 2 weeks. Along with
So-
my-
This will be a common order, both things.
Highly your lordship.
Yes,
Your Lordship, on behalf of Mr. R. Saikia,
Yeah.
due to his illness, he's undergoing treatment at Guwahati. So this matter may be listed after 1 week. Then.
after 1 week.
Yes, sir.
Mr. R. Saikia, learned counsel for the petitioner, is reported to be undergoing medical treatment at Guwahati on a prayer made on his behalf. This is the matter again after a week.
Yes, Your Lordship.
Yes.
My lord, this case, although RWD is implicated as respondent 6 and 7, but from the pleading, I cannot find out what are the specific allegation against the RWD. What grievance he want to sort from the RWD? There is no any specific. So it's very difficult to take instruction also.
So notice was already issued last time.
Yes.
You, whatever objection you want to raise, you file an affidavit. Isn't it? If things are not clear, you just say that there's nothing here, to be dismissed. That much.
Your Lordship, we have received the Parawise reply, so some more time may be needed for filing our counter affidavit.
You are for which department?
Yeah, I'm for 1, 2, 3, 4, 8, and 9, Your Lordship.
How many respondents are there now?
1, 2, 3, 4, 8, and 9.
9 respondents in total.
All are represented?
Yes, Your Lordship. Except 5.
Yes. Who is for the highway?
So Kaj is standing counsel for highway.
Respondent number
R. Saikia.
5.
Yes.
R. Saikia. Anyone on his behalf that? Just now somebody said he's on medical treatment. Can you accept notice on behalf of Mr. R. Saikia?
Yes.
Okay. Parties are represented by the respective councils, except for respondent number 5. So respondent number 5 is the Chief Engineer, Highway Zone, Public Works Department, Government of Arunachal Pradesh. And it is submitted at the bar that Mr. R. Saikia is the standing counsel. Mr. J. Koyum, learned counsel, submits that he will accept notice on behalf of Mr. R. Saikia, learned standing counsel, PWD. Counsel for the petitioner shall furnish an extra copy of the writ petition to Mr. So-and-so within
It was already furnished last time.
2 working days.
Okay, sir.
Okay. Next para, as paid for by the learned counsels for the respondents. For the, how much time?
3 weeks, Your
For
Lordship.
the 3 weeks time is granted to obtain instructions and to file counter affidavit.
Your Lordship, if I may intervene just for quick last seconds. Your Lordship, I'm under instruction of the petitioners to humbly pray before this honorable court for some interim relief during the pendency of this matter, because this matter has been pending since November. And this interim relief, which I'm going to pray now before the court, was by default list already mentioned in the petition. However, we have refrained from pressing it in the initial stages with a belief that the respondent may come up with the affidavit in a proper manner. So before making that prayer, Lordship, may I humbly beg you to please refer to page number 35, annexures. I would like the Lordships to at least see once the annexure, and then in that context, I will make the prayer. Page number 35 onwards, Your Lordship.
No, but where is your interim prayer?
Yes, I will lead, Your Lordship. It's in page number 22, Your Lordship. Page number 22 of the main petition. Clause 7 onwards, 7 and 8.
This is to dampen the road, to prevent the dust from flying here and there.
Yes, Your Lordship. And the second one is more important. There is also dumping of the sand gravels, at least on the pendency, because these photos which are shown in the petition, Your Lordship, are right outside the gate of school, medicals, and the zone where the highest public utilities are are situated in Likabali Town, Your Lordship. Most dangerous is page number 40, Your Lordship.
No, you're confined to the prayer number 7.
Yes, Your Lordship.
What is this?
Yeah, basically, we are praying here to direct the respondents, whoever is responsible for this particular roads, basically the Deputy Commissioner Lower Siang, Executive Engineer PWD of the Likabali, and Executive Engineer RWD, because these roads are village roads, which we have extracted in this prayer. These village roads are having in excessive amounts dust particles rising 24/7, Your Lordship, due to the unmetalled road, which is very much unmetalled and having huge ditches. So this has been left since decades back till the present day like this, Your Lordship. Now it's becoming severe for paddlers, for school students, schools situated beside this roads, Your Lordship. There are 2 to 3 schools. Medical is there.
What is the main prayer in the writ petition?
Not the interim, Your Lordship, not the interim. In page number 21, Your Lordship, clause 3, issue a direction to respondent number 3 and respondent number 4, which are actually state road authorities, to expeditiously develop village roads at the zone mentioned in para 10B. I'm referring to the roads which are mentioned in the petition. Issue by the virtue of Arunachal Pradesh State Road Regulation and Development Act 2015. Clause number 4, prayer 4 is issue a direction to respondent number 5, Chief Engineer Highway Zone, to repair the portion of the national highway extracted in para 10C and wash away the thick layer of fine sand deposited thereof by exercising the legitimate authority vested in them. And prayer number 5 is issue a direction to respondent number 6 and 7, who are Secretary Water Resource Department and Executive Engineer Water Resource Department Lower Siang, to expeditiously develop a concrete drainage system wherever required beside the village roads mentioned in para 10B to curb the menace of waterlogging caused thereto on rainy days. The photos are very explicit, Your Lordship.
What is the stretch of the road? This is in and around the Likabali town.
In the Likabali town, these are village roads, Your Lordship, village roads.
No, are they not identified? Which are the particular roads?
Yes, they have, Your Lordship, they have.
Where have you mentioned
Yes,
that?
I will lead Your Lordship humbly to that particular page. It has been clearly stated. In page number 9, Your Lordship. Page number 9.
Yes.
Under clause 1, 2, 3, 4 are the village roads. few stretches, hardly 2 kilometers in total or 3 kilometers. And immediately in the next page, para 10 is the portion of the national highway. So this is the only roads concerned in the petition. Category of village roads first, and second is the small portion of the national highway, where already unreported incidents have occurred.
No, page 9, this subclause 1, 2, 3, and 4.
Yes, Your Lordship.
And
Yes.
page 10, which one? Number 1.
Clause 1, yes, Your Lordship. It's
From SBI.
50 meters approx portion of national highway. Photos are attached, certified to be true copy as an annexure, Your Lordship. And even prior to filing this institution of this writ petition, we have even sent representation, to which we got no reply, and force compelled by this, we have approached this court, Your Lordship.
Who is maintaining this? Who's supposed to maintain these roads?
Since it's a village roads, the first category,
These are not metal roads. These are kacha roads.
unmetal roads, complete kacha, Your Lordship. 0.2 meters are hardly metal somewhere. It is also eroded now over time. These are village roads to be maintained by Rural Work Department, Your Lordship. When it comes to issue of dust, when it comes to water logging, WRD has been implemented as Water Resource Department for drainage issue.
No, who is responsible for constructing roads within the state?
There is Rural Work Department when it comes to the village roads, by the virtue of the State Road Authority, State Road Act, which is cited here in the petition. When it comes to highway zone, which comes under PWD, PWD, and partially also under the Chief Engineer, PWD Highway Zone. So both of them are here.
So these roads will be under what? Rural RWD?
RWD, the village roads, explicitly RWD. But now this is a fact I would like to disclose, Your Lordship. In Likavali, particularly this is the practice. At times we have seen truly that even PWD have interfered to manage the roads. Mostly when you look at the act, it's the RWD, the GO. But de facto, sometimes PWD also intervenes. They have sometimes back they have mandated some roads here and there. Hence, we have implemented both RWD and also the PWD also.
So who's appearing for RWD? You are there.
Yes. That is why I have made a mention. Whether that road was executed with the RWD and is being maintained by the RWD. Specific,
No, see, page
there
9.
should be a specific.
Page 9, some roads have been mentioned here.
Yes,
Page 10 also, one portion of road is mentioned.
yes, that is.
So now they say that these roads are not maintained properly. It's very dusty and all that. So I think you should get some instructions on this.
Yes.
What is the steps taken? Or is it not the concern of the RWD? It is not within your jurisdiction or like that.
Okay.
Whatever it may be. You get instructions.
Your Lordship, may I humbly direct the Lordships to one annexer. It's very important, I believe. Page number 36, Your Lordship, kindly. Page number 36 of the petition. These ditches goes as depth as 2 meters right outside the gate of 2 private schools. On the right is New Life Mission School. On the left is Green Valley School. And this is right outside the gate where the students travel every single day. And this has been left like this. And there is electric pole just attached to this water, which we are not able to show much clearly when it comes to electric pole. This is the one, Your Lordship. This is small scratch what we are presenting before this court, the larger picture, Your Lordship. This hasn't been covered by any sort of sand, gravel, no dumping has been done. Wall representation has been made already before also. And page number 40 is much dangerous, Your Lordship.
What is page 34? This is your notice.
Page 34, I have to see, Your Lordship. Yes, Your Lordship. Page number 34 was kind of representation, which was sent to the state authorities, actors in the recovery town under the instruction of 39 to 40 common citizens of the recovery town.
Why have you mentioned their names? Is it required?
I believe, Your Lordship, so that it may be reached properly. I was out. I usually stay in Meghalaya, so before it has happened, that letters have then we turn down, come down.
No, see, the authorities will keep on changing, you see, by transfer, retirement, all that.
Yes,
So just mentioning their official capacity is enough.
we will take care of this.
You need not mention their personal names.
We will
Okay.
take care of this, Your Lordship. Hence, as a due diligence in the petition has been corrected, we have purely mentioned the chair in the petition. We have refrained thereon from making the names in the petition.
Next, you write the petitioner. In paragraph number, what is this paragraph number?
Sorry, Your Lordship. Pardon.
2, 3, 6, 7, 10. In paragraph number 10,
Yes, Your Lordship.
bracket capital B,
B.
just a minute, Mr. Counsel,
Okay.
I've got it. We'll ask you if you require your assistance, otherwise you don't intervene. In paragraph number 10, bracket capital B, bracket small Roman 1, dash, bracket small Roman 4. And also in paragraph number 10, bracket capital B, I'm sorry, bracket capital C, within bracket small Roman 1, has indicated the stretches of the road stretches, which are in a very bad shape and requires immediate repair. Stop. According to the petitioner, the roads are very dusty, and that there are ditches which are as deep as 2 meters in these THESE, these stretches of the road. Stop considering the projection made by the petitioner. Learned Standing Counsel, RWD, shall obtain instructions by the next returnable date. This matter again. We'll have a date. 3 weeks, isn't it? This matter again on 2nd of April.
Yes.
Yes.
That's it. Lordship,
Yes.
we have served copy to the parties as per the last court order. We have been given direction to furnish copy to the parties. Accordingly, we have furnished copies. Exactly what is the status of the noting, I do not know. In this case, matter may be admitted, and on the first occasion, it was a hearing over the part of maintainability. The first day of hearing, and thereafter matter was fixed for and as per the last court order, copy was to be furnished. Whether
Yes. Who are there for the others? You are there? Which
I am
respondent?
for 3 and
Yes.
4,
yes,
but
this-
my name is not reflected. My name may be reflected there.
yes,
Respondent number 3 and 4.
RWD department, respondent, standing council, RWD department. Land management is there, and central government standing council is there.
3 and 4 is RWD.
RWD. And government is there.
I'm for 1 and 6, Your Lordship.
1 and 6. Yes, 1 and 6.
Yes. Then what about 2, 5?
Land management.
Okay. Okay. So all of you have received the copies?
Yes, ma'am.
We have not received extra copy, Your Lordship.
Hmm? You're for two only, isn't it?
Yes, sir. Yeah, 1 and 6, Your Lordship.
Oh, sorry, 1 and 6. You have not received extra copy.
Yes, Your Lordship.
Now, why is it listed today? This is listed for.
My lord, if I correctly remember, last time we raised the maintainability.
Hmm.
My lord, this is pertaining to PMG's role.
Hmm.
The Pradhan Mantri Gram Sadak Yojana. Now, these are the special package in the name of the Honorable Prime Minister, my lord, for rural road connectivity, my lord.
Hmm.
Now, it is the duty of the state government to provide the land free of cost, my lord.
Hmm.
Now, there is no any scope for compensation, land compensation. Now, my friend is asking for expanding the scope of that Pradhan Mantri the Sadak Yojana by incorporating, my lord, land compensation, my lord, which is not permissible, my lord. When the scheme does not consist of any land compensation,
Hmm.
then my friend is asking for land compensation in the pattern, my lord. The scheme itself is like that, my lord. It's a rural road connectivity, my lord. The land has to be provided free of cost, my lord.
How are they affected? Your lands have been affected.
Few village people, my lord. This is a lordship. This is a public interest litigation.
Hmm.
In this case, the plea of the government is that since this is a rural development agency is executing Pradhan Mantri Gram Sadak Yojana road, that is the step taken by the government. But we are to say
Hmm.
this, although this constructing the road in public interest, they should follow the procedures, because they're always the plea of the government is that in the Pradhan Mantri Gram Sadak Yojana case, there is no package for compensation. Whereas, as per the guidelines, that is not the case. As per the guidelines, the government has to make land availability certificate, and they're depriving the government agencies, government is depriving the landowner, saying that there is no package. That is why they, without knowledge and consent of these innocent landowners, land villagers, they are executing the project. And that is one of the aspects. And another aspect is, while executing all those projects, they are not maintaining any data of forest laws. Whereas in all those executing projects, there is a large scale damages of indiscriminate damages of the forest laws. As per the forest laws, there are many judgments of the Honorable Supreme Court also. As per the guidelines also, they have to comply it. While executing the project, it has to be acquired, and land availability certificate has been, I think, already has been given by the. Even then, how much forest is lost, how much area is to be covered, how much non-forest area is to be forest area is to be converted into a forest, non-forest land, non-forest area for construction of developmental activities. That data has to be there. If such procedure is allowed to be continued, then there will be very
Who is executing the work?
lordship.
RW.
RWD is the executing agency. That is why there is two aspects in this PIL. One is, without informing the landowner, they are saying, government is saying that there is no package, you cannot have any compensation. That is one of the aspects. Another aspect is, their RWD is not maintaining any data. Exactly how much area of the land they have acquired. They have converted non-forest area into a forest area into non-forest area in terms of environmental guidelines. That is there. That has to be there. That is the issues involved in this PIL.
So in order to enable this court to have a proper picture of the case projected by the petition and the objections raised on the maintainability, why don't you file a short affidavit on the maintainability
Now, my lord, this.
so that we can have it?
My lord, so far, this scheme is concerned, my lord. First, my lord, DPR is prepared. My lord, before preparing, my lord, they take the confidence of the village authority, my lord.
Okay.
Because the beneficiary will be the village, my lord. It's a road connectivity, my lord. So district administration, what they do, they take the consent of the village authority and they take the clearance from the forest department, my lord. What my friend is harping on, my lord, there is no forest clearance, all these things. After all these documents are collected, my lord, then my lord, DPR is sent to the central government. Without any clearance, my lord, there is no scope of my lord, sanctioning this project. My lord. That has to be given by the state government to the central, my lord, before sanctioning, my lord. So enter this club with the DPR, my lord. Land acquisition, mala free encumbrance, forest clearance, then DPR, mala total project cost, kilometer, everything's are given. After that, only mala the central government the sanctions, mala. It's not like that, mala will say the
Alright.
proposal they'll sanctions.
All right, you take those stats by way of an affidavit, preliminary affidavit on the maintainability, so that we can proceed. Please write down. The parties are represented by the respective counsels. Mr. T. Tapak, learned counsel for the petitioner, submits that in terms of the last court's order dated 12/9/2024, the petitioner has furnished copies to the learned counsels for the opposite party. Stop. Ms. P. Pangu, learned government advocate, however, submits that she has not received extra copies of the writ petition, and therefore she is unable to take instructions. The petitioner to furnish the learned government advocate extra copy of the writ petition within 2 working days. Stop. Next para, the matter pertains to implementation of the PMGSY projects in the state of Arunachal Pradesh. And according to the petitioner, the respondent authorities, mainly the RWD is carrying out the road developments without following proper procedure, and thereby depriving the genuine landowners of land compensation, which are otherwise entitled to them. Stop. He also submits that the state authorities are not maintaining proper data as to how much forest land has been converted into
Non-porous.
non-forest land.
Non-porous.
Stop. He therefore submits that if the same is allowed to go on, there would be chaos. Stop. The Mr. R.H. Nabam, learned additional advocate general, on the other hand, submits that under the PMGSY guidelines, there is no provision for giving compensation. And therefore, the guidelines cannot be modified
Or expanded.
or expanded. Stop. Next para. This court, by order dated 30/7/2024, had also made an observation that maintainability of the writ petition would be left open to be considered at the next date, on the next date. To stop. Therefore, having regard to the preliminary objections raised by the learned counsels for the respondents, 3 weeks' time is granted to them to file an affidavit raising preliminary objection on the maintainability of the writ petition, so as to enable this court to consider the same appropriately. To stop in view of above, let the matter be listed in the first week of April on a date to be fixed by the registry. And the counsels for the respondents may file their respective affidavits in the meantime. Registry shall also reflect standing counsel RWD in the cost list hereafter. Yes.
Wait, please, Your Lordship. Your
Yes.
Lordship, we have been directed to furnish the notice of service before this honorable court, and we have submitted the copy, and from respondent number 3 to 25 has been served, Your Lordship.
What is this IA?
Well, IA is for condonation of delay, Your Lordship. It's a
Condonation of-
POCSO matter, Your Lordship. Here, the convicted person has been convicted for death penalty, Your Lordship.
You are for the.
I am for the state, Your Lordship, for the state.
For
The
the-
SIT is also there, special PP, but today he is not appearing. Your Lordship, one more issue is here, Your Lordship. There is some irregularity in this appeal, Your Lordship. It is supposed to be prepared by the convict person, but the convict relative has prepared.
Okay.
Then that need to be corrected, Your Lordship.
This IA is for condonation of delay.
Yes, Your Lordship.
And who's the counsel for the petitioner or the applicant, appellant?
Mr. Dabu was there, Your Lordship.
He's not here today.
He is not present today.
Cause this indicates Rimo Riba.
He is a junior of K. Dabu, Your Lordship.
Is the
Perhaps
junior.
his name in there in the Wakalat Nama.
What is his name?
Dabu, K. Dabu, Karyom Dabu.
K. Dabi.
Yes, Your Lordship.
It's listed for, why is it listed today for?
It's for admission, Your Lordship.
No, it's listed for orders.
Okay.
And how many respondents are there? 3 to 25.
25, Your Lordship.
Who are all these respondents?
POCSO matter, Your Lordship. It's our victim. It's a POCSO matter.
I understand, but
Yes.
how many victims are there?
25, Your Lordship.
25 victims.
Yes, Your Lordship.
How can that be?
20, yes, Your Lordship. It's a school, Your Lordship.
Oh, in the school.
Yes, Your Lordship.
I see.
One, molestation, yes, Your Lordship. 1 and 2, 1 is the state and 2 is special PP, Your Lordship, or SIT, since investigation had been carried out by the SIT. From 3 to 25 is the victim.
They are the victims.
Yes, Your Lordship.
And they have been served.
Yes, Your Lordship.
How?
Your Lordship, through PP office, Your Lordship.
Okay. And how do we appreciate that you have served notice?
Yes, Your Lordship, we have, in fact, Your Lordship, we have not produced the original copy. We yet to receive the original copy. That was communicated us through email. So we have furnished it to the registry, Your Lordship. It is there in the record, Your Lordship.
Where? Which one?
This is the copy. It's mentioned in the office note, Your Lordship.
Office note mentions that, but what is the document to support the office note?
That is the scan copy, Your Lordship.
This is not in the file.
We have received this copy from the officer.
Otherwise, Your Lordship may await for the original copy because this is the scan copy only. We have received it through mail only, Your Lordship. Original we have not received yet, Your Lordship.
This office note, on what basis? On what basis is it written? This one. Service report of respect of respondent 3 to 25. public prosecutor, returning no duly served notice. Okay. Officer in charge. Oh, they have given signature also.
Yes, your lordship. But some has been received by the relatives here also. Brother, maternal uncle.
So
And your lordship, after service of this is the first time this matter has been come before this honorable court. Let your lordship wait for 1 more week, your lordship, so that if they would like to engage their own counsel, if they are not engaging, then your lordship may appoint from the legal aid council.
All right.
And your lordship, one issue is your lordship, the regarding your lordship, this complaint, this appeal has been prepared by the relative of the convict, your lordship, which is not permissible, your lordship. It has to be prepared by the convict itself.
But the appellant is not here today.
Yes.
In
That
his absence, we cannot direct him also. Let him
Okay.
appear.
Okay, your lordship, next.
None appears for the appellant stroke applicant when the matter is called. Stop. However, Mr.
T. Atta.
E.
Atta.
Ratan.
Atta. ETE, your lordship. Atta.
Ete.
Yes, your lordship.
How do you pronounce it?
Atta. We pronounce it Atta, but your lordship, most of people are finding difficulty in saying
Yes,
Atta. They
yes.
say Ete. It's
Atta.
Atta. Atta. Yes, your
But the
lordship.
spelling is
ETE.
Then
D.
let us.
ETE.
T for Tripura.
Yes. Elephant, Tripura, elephant, your lordship.
Mr.
That's why you pronounce it like it only.
Yes, your lordship.
Because ETE. And
ETE.
you pronounce like
Atta. Atta.
Atta.
Yes, your lordship.
You are the PP.
I'm additional PP, your lordship.
Mr. E. Atta. E. Atta. Learned additional PP appears for the state. And he submits that notice upon the respondent numbers 3 to 25 is complete. Stop. In this connection, the learned additional PP has drawn attention of this court to the acknowledgement received back from the victim or the relatives, which is duly forwarded by the officer in charge of police station Monikong, Xiaomi district. Addressed to the public prosecutor, Guwahati High Court, Itanagar Permanent Bench. Dated 6/16/2025. Stop. Upon perusal of the same, the notice is accepted to be served upon the respondent numbers 3 to 25. Stop. However, no one appears on behalf of the respondent numbers 3 to 25 today. Next para. The learned additional PP further submits that the appeal has been preferred by a relative of the accused person, and the same should be rectified as an appeal preferred by the accused person himself. Stop. However, since the appellant is not represented today, and at the same time, the respondent numbers 3 to 25 are also not represented, the matter stands adjourned to be listed again after a week.
Yes, sir.
Stop. It is also provided herein that if there is none to represent the private respondents on the next court date, court may consider appointing an amicus curiae / legal aid counsel to represent them in the case. Now, what about delay? I think we should note it. What is there?
5D.
Oh,
For IA only notice was issued, your lordship.
only IA.
Yes, your lordship.
Then you write one next line. Mm. By filing this application, the applicant has sought for condonation of 5 days delay in preferring the connected appeal. Mr. So-and-so, learned additional public prosecutor, fairly submits that he has no objection if the delay is condoned, so that the appeal can be taken up on merit. To stop in view of above, the delay of 5 days stands condoned. This is the matter again after a week. No, condone. IA stands disposed of. This particular order, you make it a thing in the IA. Then the other order will go in the appeal. Okay. Appeal will be listed after a week.
Yes, your lordship.
IA is disposed of.
Yes, your lordship.
Okay.
Deeply obliged.
Your Honor, I, on behalf of the Arts Honor, actually, matter has already discussed already discussed my Arts Honor. So, if there is a remaining more remaining discuss about this matter, it will be available tomorrow. But the leading counsel will be available tomorrow.
The next day, other side will appear. And the third day, the other side will again appear like that. So you're dragging on the matter like that. Huh?
They've been hard already. And that day, I was not keeping my eyes of counsel from the other side. It was not given, but in my absence, they have argued their part.
No, but there was nobody to mention on your behalf. You should have requested some of your colleague or some of your juniors to mention that you are not keeping well. No, that is between you. Despite his denial, you could have asked the court through somebody that you are not well, so that the court also can perhaps convince the counsel that you can have it some other day. He did not do that. So nobody stood up. He was there, he started arguing, so we thought everyone was ready. End of the argument, they say that the other side is absent today. So that's why it remains a part hard. Otherwise, we could have completed the matter that day itself. We also failed to take note that there was nobody on the other side. We started hearing him, thinking that they will appear. Anyway, those are gone issues, foregone. I mean, they have already, that part is over now. Now we have to look forward what to do now today.
Time for the respondent number 2 and 3.
Yes.
My part may be kindly hard.
Surely, we are here to hear you only and to finish the matter, not to delay everything like that. So you are there for which respondent? You are for tourism department. And what about the RWD? Mr. Tarak is there. You are Mr. N. Pada. And you are Mr. G. Tarak. You have nothing much to submit. Preliminary estimate
We have only one estimate, preliminary estimate,
for the additional work.
additional.
And
Whether that estimate was sanctioned or not sanctioned, that also.
no, after the work was completed, did you have any sort of measurement of the work done? No bill was prepared, no measurement was done. You only made an estimate. So on the request of the appellant. And the appellant says that he has been asked by the Secretary of Tourism Department to continue the work.
This is not having to be displayed because all along they have approached this format by suppressing and concealing national tax manner. The fact manner is that many years back.
How the government department can prepare an actual estimate only on the request of the appellant without the legal.
Correct, correct. So you begin your argument, we'll hear you.
So my lord, to me, my lord, my respectful submission would be, my lord, that there is no ambiguity, irregularity, or any infirmity on the part of the in the findings of the learned single judge, my lord. Because the fact remains that, my lord, 9 years back, there is way back in 2016, my lord, the same issue was raised by the same petitioner, my lord. And this honorable court was pleased to dismiss that writ petition, my lord, filed by the present appellant in the 2016, my lord.
Please,
and that facts.
Please take us to that order. Is it the next year?
Yes.
Page number?
My lord, may I read only the operative portion of the.
This is not annexed in the appeal.
In the appeal, it is annexed, my lord.
It is annexed.
Yes.
So issue us from there only.
Yeah.
Instead of taking up separate paper like that.
My lord, this is annexed at page 91, my lord. The operative portion is page 91.
Page 91?
Yes, my lord. May I read it out, my lord?
Just a minute.
Only the operative portion.
See, reading of operative portion will not do. We would like you to read the beginning portion also.
Obliged, my lord.
You come to page 85. 85 is the beginning.
Yes, ma'am. From 88 from onward.
Then from 88 is the order.
Yes, ma'am.
Just read from the second paragraph.
Yes, ma'am. By this writ petition, the petitioner has challenged the notice number so and so, the so and so, issued by the Deputy Commissioner Chairman Ganga Lake Management Committee, Itanagar Capital Complex, directing the petitioner to vacate the tourist complex at Ganga Lake by 15/7/2016 from the date of the issue of the said notice without fail, and to hand over the ticket counter, all the assets at Ganga Lake and tourist building, observing that otherwise it will be considered as petitioner's forceful occupation and extortion of tourists, since the petitioner is collecting fees from the tourists visiting Ganga Lake without any authority, my lord. So
this is the premise on which the writ petition was filed.
Yes. Because he was
for vacating the Ganga tourism spot and the ticket counter, you vacate.
Yes.
If you don't vacate, you will consider you to be indulged in extortion.
Yes.
So against that he has come, WPC 354.
Yes.
Not for that additional work.
But my
You are trying to project that he has come for the second time, for the same cause of action.
yes, but
But the beginning part shows that
his prayer, my lord, prayer in the writ petition was the same as the one at hand, my lord. Only because he was found to be unscrupulous occupant, my lord. Nobody authorized him to stay there. Nobody authorized him to collect fees from tourists, my lord.
correct, but today in this writ appeal, we are not concerned about the fees.
Yes.
We are concerned about the unpaid dues for for making the additional work.
Yes, so while dismissing the writ petition, my lord, liberty was granted to the petitioner to
That was an
file.
observation.
Yes, ma'am. To
But where do we have a copy of the writ petition? 354
yes, my lord, in the
to show that there is a
writ
prayer.
writ appeal itself, my lord.
354.
354. my lord.
Writ appeal is against some other writ petition, not 354.
357 we have, sorry, my lord, 354 writ petition we don't have, ma'am.
Please get the file 354 disposed.
The prayer was same, my lord.
It's not here, Mr. Santos. Have this come here? 354. This is a dispose of writ petition. We get it from the report section. 354 of 2016. Disposed on 14/7/2016. We'll get the writ petition and see for ourselves whether the prayer is same or not.
Yes.
Meanwhile, you can continue.
My lord, it is reflected at even page 106 of the order, my lord, judgment. May I read it out? Page 106, ma'am.
Judgment in which case?
Yes, page 106, ma'am. Of WPC 354.
Right? This is the same thing. Page 88 and page 105 is the same thing.
Yes.
Why it is annexed two times?
Though the petitioner submitted that he constructed 4 rooms of staff quarters, septic tank, police bed point, restaurant within the said tourist complex of Ganga Lake. So it's consistently since 2016 he has been making the same prayer, man. And this is exactly the same prayer which has been made by the petitioner, man.
Okay.
In
Then?
357 also.
Then?
Then
So what is your submission?
so, my lord, the petitioner, my lord, has miserably failed to prove that he fulfilled the ingredients of Section 70 of Indian Contract Act, my lord, because there has to be agreement.
See, your argument is something else, and what you're trying to submit is something else. Your argument is that earlier also they've come. He has come,
Yes.
filing this writ petition,
Yes.
same prayer.
Yes.
Today again he is coming with another writ petition, same prayer.
Yes, ma'am.
So conclude that first. So what happens then?
Thereafter, my lord, the observation of that writ petition 354, my lord, was basically he was granted liberty to approach the civil
No,
court, my
you have
lord.
missed the bus. You have missed the point.
Yeah.
Argument in that case and this case same. Pleadings are same, prayer same. Then what happens? What is the principle?
Then,
It is
my lord,
attracted.
then, my lord, instead of approaching the civil court or any preparing any appeal.
What is the term res judicata means? What does it mean? Res judicata. What does it mean?
Yes, my lord.
What does it mean? Res judicata.
The
Principle.
issue, the issue that has already been settled, my lord.
Settled and already raised earlier.
Yes.
Something like that.
Yes.
In this case, earlier also he has come. Court said that, oh, you go to civil
Yes.
court. Again he has come.
Yes.
So he has stopped from raising the same issue.
Yes.
That is one point.
And my lord, not only res judicata, my lord, even constructive res judicata, my lord, because he ought to, he failed to.
Correct, all that thing. So you submit on that.
Yes,
You are straight away jumping on section 70. Section 70 will come slowly.
yes,
So as far as the first argument is concerned, it's res judicata, constructive res judicata.
yes.
He's stopped from raising any such issue at this stage, since he has already raised at some point of time. And in respect of section 70 of the Contract Act, he failed to establish any case according to you. How is that? Please continue.
So, my lord, instead of, my lord, preparing any appeal, my lord, against the judgment of the 2016, my lord, he again approached this court with the same prayer, my lord, by the writ petition number 357, my lord, of
Yes.
2020. And that was rightly rejected by this honorable court, my lord, on merit, my lord. Because on merit, his case was already disposed of by WPC 354, my lord. And without bringing any new ground, my lord, he yet again filed a writ petition, which was dismissed again by this honorable court, my lord.
How many writ petitions in all? 3?
2, my lord.
2.
Yeah.
Then why are you saying he again filed writ petition? Okay, yes, the second one.
Yes, my lord.
Second was dismissed. This is appeal.
Yes.
Correct. It was dismissed on what ground?
On the ground, my lord, that the petitioner does not fulfill the criteria of Section 70 of Indian Contract
70,
Act, my lord.
correct.
And relying on some judgment also, my lord. So, may I place some judgment, my lord?
Factual aspect you finished?
Yes, ma'am.
Factual aspect. Because some assessment was made by the RWD. Some what do you call, estimate was made by them. In terms of the estimate, he has executed the work according to him. And the verbal assurance given by the secretary.
No.
Secretary of the Tourism Department. And I think there was director also mentioned.
But my lord, if any assurance was given ever by the secretary, my lord, it should have been substantiated with documentary proof.
That document is not there. It was verbal assurance. Now, thing is that the work done is not verbal. Let there be building stands. It doesn't happen like that. He constructs, brings the material, building is constructed. Are you disputing that there is no building constructed by him?
No, yes, from the beginning, the department is not using any infrastructure erected by him.
How do you say that?
Or even on the counter affidavit in WPC 357 also, we have made that contention, man.
Let us see that. You show us that before you come to the judgment. We have to clear our minds on the factual aspect.
It is not within the knowledge of the department, my lord. At page 95, my lord, of the writ appeal, we have mentioned paragraph 8, my lord.
This counter affidavit is by Tourism Department.
Yes, by Tourism Department, yes. May I read the page 8, my lord?
Yes.
That in regards to the statements made in subpara C, D, E, F, and G of the paragraph 5 of the writ petition, the deponent unequivocally clarify hereon that the so-called construction of 4-room staff quarters, septic tank, police outpost, and restaurant as mentioned by the petitioner must have been undertaken and carried out by him from his own resources and at his own capacity. Towards that end, the deponent further clarifies that the petitioner did not obtain any prior permission and requisite approval from the tourism department before carrying out any such construction work. Situated thus, the Department of Tourism cannot be blamed for a work which was not known to it, nor was ever approved by it, my lord. Because if these things are, my lord, allowed and encouraged, tomorrow this court will also be flooded with such litigation, my lord. So they are actually unscrupulous occupants, my lord, by using muscle power, forceful means, my lord, threatening the departmental head, my lord. There are some, even in another case, my lord, at Likavali case also, same thing happened, and that was also dismissed, my lord, by this honorable court.
But what is there to support your submission? From where you're submitting that? They're forcefully occupied by muscle power, all that.
Yeah.
Anything mentioned here in your counter affidavit? See, what we want to know from you is that the building was constructed by giving him the permission. And while doing so, some more additional work was done by him, which according to the petitioner or the appellant was on the verbal order passed by the Secretary of Tourism Department and the Director.
So no.
And it is a verbal order. There's no document. Petitioner also does not deny that this is a document which authorized me to construct. He also says that on the verbal assurance given, I have made the construction. Now, question put to you is that after that work was completed, whether with your knowledge or without your knowledge or whatever, or constructed as per his own individual resources, that's besides the point. The query we have put to you is that whether that constructed building has been utilized by the tourism department or not. Or have you asked him that you demolish and take away or whatever extra construction you've done?
Yes, my lord.
We are not concerned with your extra construction. You demolish it, take it back.
Yes.
Have you done that? Or you're using it instead?
Not using, my lord. And
where have you stated that?
Yeah.
That we are not occupying any of that building which according to him has constructed. Because there are three basic ingredients of Section 70. We'll come to that ultimately. Section 70 has three ingredients.
Yes, yes.
So if those ingredients are fulfilled, then you have to pay. If they are not fulfilled, then you don't have to pay. That is why I'm asking you all these questions.
My lord, the third ingredients of Section 70, he doesn't fulfill, my lord.
Yes, how? Show us.
Yes.
You only denied that it is not within your knowledge. That's all.
Yeah.
You don't deny anywhere that you are not using it.
Because, my lord, subsection 3 of Section 70, my lord, clearly stipulated. And the third is that the other person for whom something is done or to whom something is delivered must enjoy the same on benefit thereof. When these conditions are satisfied, Section 70 imposes upon latter person the liability to make compensation to the former in respect of or to restore the thing so done or delivered, my lord. So, if anything is due, liable to be paid to him, my lord. At best, my lord, the petitioner might seek compensation in the civil court, my lord, but not by way of filing repeated writ petitions, my lord. Because no such construction work is within the knowledge of the secretary, my lord, because that is only concocted and manufactured statement, my lord, on the part of the petitioner. He was never ever even verbally accorded any sanction or approval, my lord, to construct. Later on, it was discovered, my lord, that he forcefully occupied the tourist lodge and started collecting fees from the tourists, and he must have done some repairing works, my lord, on his own expenses, my lord, in an unauthorized manner. So for that, the tourism department cannot be liable man for payment of any compensation.
Okay. Then what else? Have you got the file? Paragraph 4. Paragraph 4, yes. But paragraph 14 is only against that location. Against location.
It's for the then extending this. That much. But 4 is for 30 days of suspension, all these things are there.
He is not stating anywhere that this has been forwarded by the secretary or something like that.
No, it's not.
Simply statement is that.
Additional estimate was made only replacement by so there was no other additional. Regarding the use of facility, that's kind of how can we process. It reach but still includes additional structures.
Yes, Mr. Pada.
My lord,
Further, you have any further submission? You have further submission you have? No means.
page 106, which my friend has referred.
Hmm?
Page 106 of the judgment.
Hmm.
Writ petition 354. So regarding the claim, beside he challenged the eviction notice, he has also raised the pending bill also. This reflects. This is same septic tank, same police bids, same ground which he have claimed, which was rejected. Though the petitioner submitted the construction 4 rooms of staff quarter.
Hmm.
Same is the claim which has been made in the present writ appeal. Septic tank, police, bed points, restaurant with said tourist complex of Ganga Lake of is owned by spending money for about 38 lakhs. Now also claim is that around 38 lakhs. In terms of assurance of the repayment, assurance made by the respondent tourism department, but the petitioner failed to show any such assurance given by the respondent concerned. So suffering this fact, he has filed with petition 357, which was again dismissed and agreed by the said dismissal. Now he has filed this writ appeals. So in the said writ petition, he also not mentioned this. So it seems that in writ 357, this pending bill was also one of the issues raised by the petitioner at the present appellants. So which was rejected by this honorable single bench of this honorable court. So now at this stage, otherwise also this courts. And he has in the course titling, he has mentioned that it is admitted pending bill. Nowhere the authority has admitted there is a pending bill. He have clearly stated that this is admitted pending bill. This is not admitted, there is disputed. When there is a disputed facts, this court cannot adjudicate. So in 354, learned single judge has rightly stated that if you have any grievances, you have any claim, you can approach the civil court. Instead of approach the civil court, again he has approached this court by writ petition 357, which was dismissed. And against which this writ appeal is. So in the above circumstances, my lord, this writ appeal is liable to dismiss.
And on my part also, my lord, since there is no information in the finding of the learned single judge, my lord, and the petitioner has no right to unlimited drop of in force delivery time, my lord. So this is liable to be dismissed. This may be can be dismissed.
Any submission regarding section 70?
On section 70, my lord, my submission will be confined to subsection 3, my lord, which the petitioner has failed to fulfill.
What is that? The person for whom something is done or for whom something is delivered must enjoy the benefit thereof, my lord. So, from the day one, the department has been specifically clearly denying that anything constructed or erected by the petitioner is being used by the department. Within our knowledge, there is no such infrastructure. But where is that particular denial? You've read your counter affidavit, isn't it? You've read your counter affidavit, wherein you have just stated that it is not without, it is not known to you under what authority he has constructed. But you don't say that you're not using it. You read paragraph 8.
We have not, my lord, actually admitted that we are using any such structure. We have simply stated that he must have erected some structure on his own expenses, which we do. We have not admitted of using such structure. That is why I have referred to page 95 on it. There are 8 of our counter evidence. Here also we have not admitted.
Take proper care in due course of time. Without yes, we have a submission.
Yes, sir.
Who is respondent number 5?
Respondent 5 is principal with conservator of forest conservation certificate.
Yes.
Where only performer.
Performer. That's all?
Lordship, since the control and management of the Ganga Lake, where the construction has been taking place, is under our department. We are managing the Ganga Lake. That is why we have been made a party. Otherwise, we are only performer.
Okay. All right. So we'll consider and pass necessary orders. This will not be CAV. We'll get the orders by maybe day after tomorrow. All right. We show it as disposal. Mr. El Perme, is it? El Perme, learned standing counsel, Power.
Power.
Department submits that in terms of the court's direction, he has filed the additional affidavit this morning and prays that the matter be listed again after a week. So he also submits that he has taken the consent of the other side. We give above office to verify and connect the additional affidavit to the record and to list the matter again after a week.
In item number 23, my lord. Here, my lord, OPC court replying, my lord, service to respondent number 3, my lord. Private respondent number 3 not completed, my lord. I am praying for, I may be allowed to take re-step upon the private respondent number 3, my lord. Re-step, my lord.
Allowed to what?
Re-step upon the private respondent, my lord.
How?
Service report to the private respondent number 3, my lord, is yet to complete, my lord.
No, how do you want to take steps? Again, by registered post?
Normal, my lord. By register, my lord.
Let the matter be called, we'll see. All right, as and when the matter is called.
Okay.
These orders, yes.
May I I beg to mention item number 10, Manoj.
Yes.
I have taken consent from the petitioner. This matter was listed on 13 March.
Item 10, why 13 March? Why not today?
No, in this, Miss, both the issues,
For the state?
yes, ma'am. This acting today.
Have you informed the other side?
Yes, ma'am.
Let this matter come up on some other day, not 10th, and not on 13th.
My lord.
You'll have it on 17th,
I'm for the
Monday.
petition.
You'll have it on 17th, Monday.
17. My lord.
That's paid for on behalf of Learned State Council. What's her name? Miss Giete. Mr. or Miss?
Miss.
Miss Giete. And not objected to by the other side. List this matter again on 17th of March 2025.
And one
Yes.
more, my lord, item number 12.
Yes.
In this, we need to file affidavit, my lord. So we need some more time.
How much time?
2 weeks, ma'am.
Okay, as paid for by the Learned State Council for the 3 weeks time. For the 2 weeks time is granted to obtain instructions and to file counter affidavit.
Your Honor, I'm for the petitioner.
Yes. Your good name?
T. Nima.
Mr. T.
Nima.
Your name is here?
Yes.
Nima.
Yes.
Mr. T. Nima, Learned Council appears for the petitioner. Yes.
Your
Lordship, with the consent of the other side, Your Lordship, I beg to mention item number 35 and 36, Your Lordship.
Yes.
May it be fixed on 7th of April, Your Lordship.
Why? We wanted.
We are seeking some instructions, Your Lordship. It has not been received till late, Your Lordship.
My lord, I am appealing for in this matter for respondent number 1, 3, and 4. And they're supposed to file the affidavit, my lord, Deputy Commissioner. So far that has not been filed. So next date on 7th of April, my lord, prior to that, they should file the affidavit. That is my prayer.
Who's for the petitioner?
My lord.
Yes. Any objection?
No objection.
Okay. Mr. R. Viram.
Y. Viram.
Y. Viram, Learned Council appearing for the respondent number
6.
Respondent number 6.
Yes, in both the
writ petitions.
yes, Your
Submits that he may be given 2 weeks time. He may be given 3 weeks time to obtain instructions and to file counter affidavit. Mr. Y. Doloy, Learned Council appearing for the
1, 3, and 4.
respondent numbers 1, 3, and
4.
Yes, you are for respondent 1, 3, and 4.
Yes.
What was your submission?
My submission, they should file the affidavit, my lord. Once the affidavit is filed, you can do that maybe.
Who should file the affidavit?
Respondent number 6.
You have filed.
We have filed our affidavit.
Mr. Y. Doloy, Learned Council appearing for respondents 1, 3, and 4 submits that the respondent he represents have already filed their counter affidavit and that the affidavit of respondent number 6 is awaited. So stop. Awaited, and therefore awaited, full stop. Considering the submissions made, let the matter be listed on 7/4/2025 as paid for. The respondent number 6 to file the counter affidavit,
No, Your Lordship, additional affidavit, Your Lordship.
to file the additional affidavit on or before the next date fixed.
If it may-
Yes,
Please, Your Lordship, I beg to mention item number 33 and 34.
33, 34.
Yes, Your Lordship. My Lord, I'm appearing for the petitioner, Your Lordship. In this case, we have to seek some instructions from the petitioner to see whether they're any more desirous in continuing with the matter, Your Lordship.
Your good name, please?
D. Tamuk. D. Tamuk.
Ms. D. Tamuk, learned counsel for the petitioners, submits that she may be given some time to obtain instructions from her clients as to whether they would like to pursue the matter any further. Stop considering the said prayer. Matter stands adjourned for how much time?
2 weeks, Your Lordship.
2 weeks. Yes, that's paid for, huh?
Obliged.
Please.
Yes.
That's why we to mention item number 19.
19.
Yes, Lordship. Lordship, I'm for the petitioner and I have taken the consent from the other council. It may be released after 3 weeks. Since the conducting council is out of station.
Who's the conducting counsel?
A Tata, Lordship.
A Tata.
Yes, Lordship.
Have you informed the other side?
Yes, Lordship.
Mr. A Tata, learned conducting counsel, appearing on behalf of the petitioner, is said to be out of station on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for 3 weeks.
Give your life.
My lord, I beg to mention item number 18. I have taken the consent of the other party. I'm the petitioner in this, so 3 weeks time may be granted, because the conducting council Tabatopu has gone through the eye surgery, so he needs some time for rest.
Mr. T. Topu.
Yes.
Mr. T. Topu, learned counsel for the petitioner, is said to be indisposed on a prayer made on his behalf. Matter stands adjourned for 3 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 22 on behalf of Mr. P.K. Tiwari for respondent number 2, NHPC.
Who? On behalf of?
P.K. Tiwari, conducting counsel for respondent number 2, NHPC. With the consent of both the parties, the matter may be listed on 18th of this month, Your Lordship.
2 and 3. Respondent number 2 and 3.
2 and 3, NHPC, yes, Lordship.
Respondent number 2 and 3.
Yes.
Mr. P.K. Tiwari, the
Yes,
senior
Lordship.
counsel.
Yes, Lordship.
Have you informed the other side?
Yes, Lordship.
What is your good name?
E. Payang. E. Payang.
Miss E. Payang. Mr. E. Payang, learned counsel, submits that Mr. P.K. Tiwari, learned senior counsel, appearing for respondent numbers 2 and 3, has some personal difficulties to appear before the court today, and therefore prays that the matter be listed again on 18/3/2025. Stop. He submits that he has also
My lord, I appear on behalf of M. Kato for respondent number 125, my lord. My
So-
lord, affidavit is ready. Some more time may be given to file.
Counsel for the petitioner praised that the matter be listed again on 7th of April 2025. Mr. Y, the lawyer learned counsel appearing for the respondent number 6 and 7 submits that the respondent numbers 1 to 5 are yet to file their counter affidavit. Mr.
N. Sora.
Sorry?
N. Sora.
Mr. M. Sora, appearing on behalf of Mr. M. Kato, learned DSGI, submits that the affidavit of respondent numbers 1 to 5 is ready and that it will be filed within
Within
10 days time.
yes.
Considering the said prayer, that the matter be listed again on 7th of April 2025 as paid for. Okay. Yes.
My lord,
Mhm.
I beg to mention item number 26.
Yes.
Matter may be listed after a week.
After?
After a week.
After a week. Let the
Leading,
matter be called.
leading counsel, my lord, leading counsel of this matter is out of it.
Who's the leading counsel?
K. Tapian, sir. K. Tapian.
It again. What happened to him? He's absent.
My interim order maybe.
Yes, sir. He's absent.
Let the matter be called. We'll pass the orders when the matter is called. Okay. Since it is listed for orders.
My lordship. So I beg to mention item 7 on behalf of Mr. D. Kamduk for the petitioner.
Item
7.
What do you want?
Your lordship, this matter may be fixed for tomorrow, that is 11/3/25.
Why?
Pardon, lordship.
Why do you want it tomorrow, not today?
Your lordship, the
There has
collecting
to be a
counsel-
reason, you see.
Yes, your
Just
lordship.
like that.
We are not ready for today, your lordship.
You're for the petitioner.
Yes, I'm for the petitioner. We have taken consent from the parties involved.
Okay, this is the matter again tomorrow as paid for by the learned counsel for the petitioner. Please give the data, 11th. Yes.
Also, your lordship, I beg to mention item 14 and 15 on behalf of Mr. R. Saikia as before due to his illness.
When do you want it?
After a week, your lordship.
Mr. R. Saikia, learned counsel for the petitioner, is said to be indisposed on a prayer made on his behalf. Matter stands adjourned for a week.
Also, your lordship, item 16.
Sorry?
Item 16.
Similar order, item 16.
Of like.
May I please, my lord. My lord, I beg to mention item number 17 on behalf of M. Kato, my lord, for respondent
Item number
17.
17.
Yes, my lord.
On behalf of?
M. Kato, my lord, for respondent, my lord, and taken consent from the petition.
What do you want?
My lord, matter may be adjourned for the day, 3 weeks time.
So they have to file affidavit of opposition.
Okay. Kato learned DSGI, appearing for the Respondent Union of India, is said to have some personal difficulties to appear before the court today. On a prayer made on his behalf, matter stands adjourned for 3 weeks. The respondents shall file their counter affidavit on or before the next date fixed. Or not before the next date, not fixed. Yes.
May I please, your lordship?
Yes.
This honorable court had on the last that direct department, health department to conduct medical test of the petitioner. And the report was to be submitted today.
If council for the comment was it. Is it Tagum?
Madam, as per last order, madam. Medical board.
What is the matter about?
The petitioner who was appearing for a constable, for the post of a constable,
Where? Which constable?
in the civil police, and also there are a lot of post lordship. Yes, state civil. Then in the physical and everything he qualified, but in the medical test he was declared as colorblind. So he could not believe it, of course. So he had made many inquiries, and he had also done medical tests on himself on different different hospitals. Thereafter, he made a representation to the APSSB. That is the Arunachal Pradesh Staff Selection. Then they reconducted a medical test in which he was declared not colorblind. But that was not acted upon, so we came before this honorable court. Now this honorable court is directed for another medical examination.
First, you were declared colorblind.
Yes.
Second test, you were okay.
Yes, but they said certain formalities were not followed. For example, like biometrics and all. So therefore, when the APSSB sought clarification from the TRIMS, there is a medical department, they said that some certain biometrics and all were not, procedures were not followed. So we are ready to do it again. So that is why this honorable court had directed for re-medical examination.
Regarding color blindness.
Yes.
But the second examination said that you are not colorblind.
Yes, within
But-
permissible limits.
But there were certain what?
When the results were forwarded to the APSSB, that is the State Selection Board, the APSSB sought a clarification as to how different medical results have come. So the medical department again wrote to the APSSB as in a matter of clarification, saying that we have done it and he was not found colorblind within permissible limits, but biometrics and all were not done as per procedure. So
Biometrics.
yes, biometrics. Of course, it was the fault of the board because they could have come, they did not come.
There was a doubt on behalf from the state selection board that by just to the impersonation. That's why, madam.
Sorry?
In the second medical board, madam, biometric test was not done. So it was not, there was a doubt that whether the person who appeared before the board is the same person or somebody else. That's the confusion arose, madam. That's why, madam, third this test, madam, medical board was constituted, madam.
Okay. It is not in your favor.
Then I have no case.
I'll just read it for you.
Yes.
With regard to so-and-so, the board has examined the candidate so-and-so. Examination was conducted after doing due biometric process and in the presence of executive magistrate. The whole process was conducted under videography. There are two pen drives here. The board has found the candidate is suffering from color blindness. The medical board report is attached herewith for your kind perusal.
Copy of that may be furnished to me as well.
Then the board observations is that the final board examination and unfit that has been ticked. Candidate is colorblind, so medical board declares the candidate unfit.
So
So no case. But Lordship, I may be furnished that copy.
I
The,
have been furnished with seal cover. Even I'm not access to the report. Madam. That's
So what to do?
but still I deserve to know.
I think we can furnish her a copy.
Lordship, let it be returned back to the concerned department, Lordship, and they can apply from there.
yes, they can get.
Because I have not access to that.
I'm already losing the case. Why do you want me to run in circles now? I think there's no impediment in furnishing me the copy.
Yes, what would
Lordship, no objection. Lordship, find it bid to furnish, it can be furnished.
Only the copy is not with us. Only what is furnished is in seal covered, and we have
That's
the
the
only
petition.
That can be photocopied. It won't take much time.
No, if you have objection, you must say that. If you have no objection, then we'll consider.
That's why if it is from the, if it's a get photo state, madam, yes, it can be done. Otherwise, we don't have a spare copy. We are not access to the report.
We'll give her a photostat, we'll give the petition a photostat. Plus, we need not go through the, what do you call, the pen drive and all that. So since everything is, should be transparent, that's all. Please, right? Parties are represented by the respective councils. Stop. On 27/2/2025, vote pass the following order. Please abstract the entire order. Today, Mr. N. Tagum, Learned Standing Council,
For health department.
Health Department, has produced the medical board report in respect of the petitioner in a sealed cover. Stop. Upon opening the seal cover, it is found that a medical board was constituted to examine the petitioner whether he is color blind or not. And the board, upon examining the petitioner, provide its report dated 5/3/2025, found him to be colorblind and unfit for the post applied by him. Stop considering the considering cancel that. The Chief Medical Superintendent, Trims Hospital, Naharlagan, has also enclosed the videography coverage of the biometrics verification of the petitioner by the APSSB staff in the presence of the executive magistrate by way of a pen drive. Stop. Next para. Upon perusal of the medical examination report, it appears that the petitioner cannot be granted any relief by this court since he has been colorblind. Stop. The read petition accordingly stands dismissed. This will go back, medical report,
My lord.
this will go back or will return here. A photocopy of the medical board report.
It has to be returned to the authority. My lord. It could, with the record.
Copy may be
it may be
written
retained.
here as a record. Part of it.
Photocopy of the medical board report may be retained in the case record. And further, a copy of the same may be furnished to the learned counsel for the petitioner. Stop the original medical board report and the videography recordings be returned, is being returned to the Chief Medical Superintendent, Chief Hospitals Narlagan, for Mr. T. Tagum, Learned Standing Counsel, Head Department. To make Xerox copy, 2 copies, one in the record, one to the counsel for the petition.
Okay.
If it may please, your lordship. My lord, on the last occasion, this court has directed the State Council to seek instruction as regard to the status of the appeal that the petitioner has preferred before the ADC Mechuka, your lordship. And also to seek instruction whether the appeal has been transferred to the competent court.
Yes.
I've not received the instructions yet, your lordship. I've spoken to the ADC. She said she needs some more time to give the instructions, your lordship.
Where was the
Otherwise, your lordship, notice may be issued. Notice not yet.
appeal? Appeal is pending before whom?
Before
ADC.
the ADC, your lordship, Additional Deputy Commissioner Mechuka.
What is the state of, I mean, what is the position as on today?
My lord, as in today, your lordship, after the coming into force of the Arunachal Pradesh Civil Court Act, your lordship, 2021, section 15, subsection 3, your lordship, proviso to subsection 3, your lordship, it provides that if an appeal is pending before the Court of Deputy Commissioner or an Additional Deputy Commissioner, your lordship, it should dispose of within a period of 1 year from the date the act came to effect, your lordship. However, there's a notification, your lordship, that has been issued thereafter that in case the appeal.
Just a minute. You're saying that it will not be transferred to the competent civil court immediately. Instead, the appeal should be disposed of within 1 year.
Within 1 year, and in case the period has been has lapsed, your lordship, that after since the act came into effect on 12 April 2021, your lordship, from that from 12 April 2021, your lordship, within a period of 1 year, the appeal should be disposed of by the deputy commissioner or the additional deputy commissioner. And in case the appeal is not disposed, your lordship, that should be transferred before the district judge or additional district judge, your lordship. And after the matter has been transferred before the district judge, your lordship, the matter can be retransferred by the district judge to any civil court, your lordship.
That is under which provision?
Under
Section
15(3), your lordship.
Section 15, subsection 3
Yes, your lordship. And
of the Civil Codes Act.
yes, your lordship.
And that 1 year will start from which date?
From 12 April 2021, your lordship.
That is the date of publication?
Yes. The date on which the act came to effect, your lordship.
This one's amended. It's on previous one.
12/4/2021. What is there in the amendment?
My lord, amendment, there were few, subsection 3 was amended, your lordship, in this amendment, and there are two, section 27 was also amended, your lordship.
You have a copy?
Yes, your lordship. Of
Okay, let
amendment.
us see subsection 3 first. The original one. Classes of courts.
Yes, your
This
lordship.
one.
15, section 15, appeal, your lordship. Section 15, subsection 3.
No. You were saying that section 3 was amended.
No, your lordship, section 15, subsection 3, your lordship.
By this amendment of 2022, Section 15 was amended.
By this act, Your Lordship. I'm sorry, Your Lordship, I'm not getting it yet.
No, act is there of 21.
Yes, Your Lordship.
Then amendment is there of 22. I'm asking you what was amended in 22.
My Lord, in this amendment, Your Lordship, that is at page number 37. Subsection 3 of section 15 was amended, Your Lordship.
Let us see the original one.
It is at page number 33, section 15, appeals, Your Lordship.
Appeals, yes. Appeals from the, please read.
Subsection 1, appeals from decree or order passed by a district court of district judge or courts of an additional district judge in original suits and proceedings of civil nature shall, when appeals are allowed by law, lie to the High Court, Your Lordship. And subsection 2 provides appeals from decrees and orders passed by a court of civil judge, senior division, original suits and proceedings of civil nature shall, when such appeals are allowed by law, lie to the court of district judge of the district or in the court of additional district judge where such court exists or the High Court as the case may be. Subsection 3. It provides appeals from the decree or order passed by a court or civil judge, junior division, to original suits or proceedings of a civil nature shall, when such appeals are allowed by law, lie to the court of civil judge, senior division of the district, provided that any appeal on civil suits pending in the court of this deputy commissioner shall be disposed of by the concerned deputy commissioners under the provisions of the Arunachal Pradesh Administration of Justice Regulation 1945 as expeditiously as possible, not later than 1 year from the date of coming into force of this act. Provided further that from the date of commencement of this act, in case an appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same, proceed with the case de novo.
You were referring to the first proviso, isn't it? Within 1 year.
Yes.
Now let us see the amendment. What does the amendment say now?
Amendment is at page number 30. May I read?
Yes.
In the Principal Act, in the subsection 3 of section 55, after the words Court of Civil Judge Senior Division of the District appearing in the last part of the sentence, the words and in the case of Court of Civil Judge Senior Division has not been established in the district to the Court of Additional District Judge or District Judge as the case may be shall be added. In the second proviso of subsection 3 of 15 as the existing entries, the following shall be substituted. Provided further that in case the deputy commissioners could not dispose of the pending appeals in their courts within 1 year from the date of commencement of the Arunachal Pradesh Civil Court Act 2021, they shall transfer such pending appeals to the courts of civil judge junior division, the courts of civil judge senior division, the courts of additional district judge or the court of district judge as the case may be, as per this territorial and pecuniary jurisdiction.
One thing you said was that it should be transferred to the civil judge, I mean to the district judge. And the district judge accordingly will endorse it to whichever court.
Yes, Your Lordship.
But the amendment doesn't say that. It says that it may be transferred to the court which has the pecuniary and territorial jurisdiction.
Yes, Your Lordship.
So you need not send it to the district judge. The deputy commissioner can send it to the competent court straight away.
Yes, Your Lordship.
Now, in your case, present case,
yes,
your grievance is that despite this provision, appeal has not been disposed of within 1 year.
Yes, Your Lordship.
So under the Amendment Act, he has to send it. And if he doesn't dispose it of, he has to send it to the competent civil court.
Yes.
So when was the appeal filed?
It was filed in the year 2011, Your Lordship.
2011.
Yes.
And that has not been disposed of till date. In the meantime, this Civil Courts Act has come into effect in the year 2021.
Yes, Your Lordship.
12/4/2021. So 10 long years it was pending appeal.
Yes, Your Lordship.
10 years.
10 years.
And as on today, is still pending. Ms. Basar, what is happening?
Otherwise, a notice may be issued, Your Lordship.
Why not we dispose of the entire petition?
Yes, that can be done.
This is the provision of law.
Yes.
What purpose will it serve if we say we should notice?
Not sure.
Where is the appeal? Let us see.
At
Page number
25, Your Lordship, Annex 3.
25. See, what we can do is, Ms. Prasad,
Not sure.
we will say the appeal. Instructions were sought for, you could not get the instructions till now.
Yes.
But seeing the provisions of law, if the appeal is not yet disposed of till date,
Yes.
the Deputy Commissioner will transfer it to the,
Later.
so and so, in terms of the Amendment Act,
Yes, yes.
within a period of
10 days, one month, Lordship.
1 month from the date of receipt of the copy
Lordship.
of this order.
Lordship.
That'll do?
Yes, sir.
Okay, heard Miss, you are Miss,
D. Tamuk, Your Lordship.
heard Miss D. Tamuk, Learned Counsel for the petitioners, and Miss R. Basar, Learned Government Advocate for the state respondents. Stop having regard to the projection made by the petitioners, comma, the writ petition is disposed of. That is, petition is being disposed of at the motion stage itself. Stop, next para. When the matter was listed for motion on 28/2/2025, this court had directed the learned government advocate to obtain instructions as regards the status of the appeal said to have been filed by the petitioners before the additional Deputy Commissioner, West Siang District, Mechuka. When did you file this appeal? Do you have any date?
Yes, Your Lordship. It was filed on 11/6/2012, Your Lordship, not 2011.
On
2012.
11/6/2012. Oh, stop. The learned government advocate today supposed that she has not yet received the instructions and that she has been requested by the additional Deputy Commissioner to seek for some more time. We'll stop. Next para. The grievance of the petitioners is that they have filed an appeal under section 46(1) of the Assam Frontier (open bracket) Administration of Justice bracket Regulation 1945 against the Gebang/arbitration decision passed on 16/3/2011 at Mechuka by the arbitration board. Stop. Despite the appeal having been filed way back on 11/6/2012, the same has not been disposed of by the Court of Additional Deputy Commissioner till date, and therefore, being aggrieved, the petitioners have filed instant writ petition. Stop. Next para. Ms. D. Tamuk, Learned Counsel for the petitioners, has drawn the attention of this court to the Arunachal Pradesh Civil Courts Act 2021. And more particularly to section 15 of the said act. Stop. The Learned Counsel submits that as per section 15, which is the relevant one?
Section 15, subsection 3, Your Lordship. Proviso, first proviso. This was amended.
What did I say? Just read the sentence. Has drawn the attention of this court to. No, you're right. Like the learned counsel submits that the Civil Courts Act came into force with effect from 12/4/2021. And that in terms of section 15, the appeal is now to be decided by the competent civil court and not by the Court of Additional Deputy Commissioner. So stop referring to section 15. No, referring to, please read that again. Referring to the proviso under section 15(3). The learned counsel submits that any appeal on suits pending in the court of Deputy Commissioner is to be disposed of by the concerned Deputy Commissioner under the provisions of the Assam Frontier Administration of Justice Regulation, 1945 as expeditiously as possible and not later than 1 year from the date of coming into force of the Act. That is 12/4/2021. We'll stop. She further submits that the Civil Courts Act was amended by the Arunachal Pradesh Amendment Act 2022, wherein a second proviso was provided under section 15(3) of the said Act, which provides that in case the Deputy Commissioner could not dispose the pending appeals in their courts within 1 year from the date of commencement of the Act, they shall transfer such pending appeals to the civil courts having the pecuniary and territorial jurisdiction. To stop. The learned counsel submits that despite the provisions of the Civil Courts Act and also the amendment of the said Act, the appeal filed by the petitioners has neither been disposed nor transferred to the court of competent jurisdiction. To stop. Not full stop. And therefore, the petitioners have filed the instant writ petition. Next para. Having heard the learned counsels for the rebel parties, and upon perusal of the materials available in report, including the Arunachal Pradesh Civil Courts Act and its amendment in 2022, the writ petition is disposed of with a direction to which respondent?
Respondent number 2, Your Lordship.
To the Additional Deputy Commissioner, Mechuka, Shiome District, respondent number 2, to transfer the appeal filed by the petitioners. What is the case number? Does it have?
No, Your Lordship.
Petitioners on 6/2022. Any number?
No, Your Lordship.
Before the court of, before the competent civil court, in terms of the provisions of the Civil Courts Act and its amendment in 2022, more particularly the proviso to subsection within bracket 3 of section 15. Provisos, provisos of subsection bracket of section 15 of the Act, of the original Act and its amendment, within a period of, no, not within, we cancel that again. If the appeal filed by the petitioners have not already been disposed of in the meantime, within a period of 1 month from the date of receipt of a certified copy of this order. All right.
Obliged, Your Lordship.
We will assemble at 2.
Please, Lordship. My lord, this is regarding admitted pending bills. Admitted pending bill. The government has admitted that they owe me, but they have not paid.
What kind of bill is this?
Those are, I have mentioned the works that was executed in page 5. One is construction of DC office building, paragraph 4. at UPA under Doimuk PWD division. 2 is maintenance of non-residential building under Doimuk PhD division. 3rd is maintenance of residential building under Doimuk PWD division. 4th is construction of multipurpose auditorium at Doimuk, Arunachal Pradesh. Now, in 2000, this was already handed over and it was constructed within time frame. This is also not disputed by them. There are several communications which I may, Lordship, which I have annexed. Annexure 1 is the Lordship communication chief engineer, Western Zone. This is 2/3/2013. Here, when I had prayed for clearance of the bill, all the works have been mentioned here. Then it is written, you are requested to keep necessary provision to clear the above bills by including the proposals in the AOP during 2013-14. Please, and meanwhile, concerned EEs and SCs have been asked for detailed examine and submit reports on the subject. Then, Lordship, the next page. Here, Lordship, the allocation was given and part payment was made on this, Lordship, after this in 2014. Thereafter, Lordship, since 2015, I have been consistently asking them to pay the rest. That has not been done. And Lordship will see the page 19 also, one such communication.
Okay, you show me which one document wherein they have admitted.
They have admitted a number of times, Lordship. Number 1, Lordship, page 25. This was in 2023. 05/12/2023, page 25. This is the communication made to me. Release of long pending bills regarding. With reference to the above cited subject, it is regretted to inform you that due to non-availability of funds, your claim for payment of rupees such and such will not be able to pay at present. This is one such communication. Then another one in the next page, same thing, sorry, saying that we are unable to pay because of non-availability of fund. This is by executive engineer. Then, Lordship, this was also forwarded to the Undersecretary PWD.
Is there any breakup of this amount, or this is a total amount?
Total amount, Lordship.
But earlier it was 67 lakhs, now it has become 89
Yes,
lakhs.
because of the interest, Lordship. As per the PW manual also, they are supposed to pay with the escalating Lordship, interest, Lordship.
No, see, into page 25.
Yes.
This is of December 3.
Yes.
You say 67 crores.
Yes.
Now, just next year in July.
Yes.
24.
Yes.
It has become 86 crores.
86.
So much of interest.
Lordship. Yes.
It has earned so much interest over.
Yes, Lordship.
It cannot be.
This, Lordship, it's they can examine and they can, Lordship, decide to pay the bills, but they are not doing anything, simply saying no fund is available.
See, we're not at that stage now.
Yes.
We are at the very preliminary stage. My only question is that figures has drastically changed.
Yes.
Just within, within 8 months, 6 months, 7 months. From 67 crores, now they are mentioning 86 crores.
Yes.
Why? Is it the same bill or is it a different bill?
Same, Lordship, same bill.
So what is the explanation for that figure?
Change
in the figure.
That calculation has been done as per the Lordship. Lordship may see page.
This figure, does it appear anywhere in your chart which you prepared at paragraph 13?
Lordship, the first one is at page 19. This is the letter to the chief to the executive engineer. Here the calculation is given 67 crores. Then
Page
Lordship,
19.
yes, page number 19. This is our claim.
Executive engineer filed by the petitioner.
Yeah, filed by the petitioner.
67.
Yes, this is in 2023.
Correct.
Then Lordship.
So this tallies with page 25.
Yes.
67.
Then Lordship, page 23. This is the in 2024. Here the 86 crores have come with the interest, Lordship. The calculation has been done as per the MSME Act. MSME Act. MSME Act.
What is that?
MSME is micro.
Savings.
Yeah, no. Small industries. We are registered under the MSME. Under the MSME Act, those industries which are registered under that, for that the percentage of delayed payments are much more than the original, even the CPWD manual. That is why, Lordship. Of course, if they are Lordship, disputing this, then they can pay as much what would be under the CPWD manual.
Okay.
But this is the claim of the petitioner. This is why, Lordship.
What you're saying is that figures may change, but this is under the permissible calculation.
Yes, permissible. Because under the MSME Act, for delayed payments, earlier it was Interest on Delayed Payments Act or something like that. Thereafter, this MSME Act came into being. Here, all the industries which are micro, small, and medium enterprise development act 2006. So we are registered under this. Under this act, the interest on delayed payments are much higher. That is why this calculation has come about.
So as on today,
yes,
how much is the?
As on today, we had calculated only till December. It is 97 crore 60 lakhs 92,414.87.
Where is that?
That is, I have made the calculation. That is page 8 onwards.
Okay.
8 to 10.
How many works in total?
4.
4 different works.
4 different works. Lordship, the latest acknowledgement, Lordship, will find at page 58. We had sent a legal notice mentioning all this at page 30. Thereafter, a reply to this is at page 58. This is 27 January 2025. This is in reply to our legal notice dated 13 2025, which I have annexed at page 30. Payment of pending bills shall be released as and when fund and LOC is received from competent authorities. Referring the chief engineer's letter dated this and this had requested the executive engineer PWD division to settle the issue at division level, but due to non-placement of fund for clearance of pending bills of your client, payment could not be released so far. This is what they have been saying all along.
Due to non-placement of fund.
Yes, it appears that the chief engineer had requested executive engineer by these letters also enclosed, to settle the issue at division level. But the chief executive engineer says that even though I have been asked to settle the issue, but because the funds have not been placed, the clearance of bills could not be done. This is his reply. The letters which is mentioned is also an annex at the next page 59 and page 60. The letters which are mentioned here in this communication. That is 17/8/22 and 17/1/23.
These are the 4 works.
Yes, these are the 4 works.
The figure is only 54.
Lordship?
Figure.
Yes. That time, Lordship, that was in 22. Referring to the above mentioned, which is referring to the above mentioned letter, this is to the executive engineer by the chief engineer, saying that detailed report against the pending bills, liabilities, bill regarding. Referring to the above mentioned letter under reference as received from Sri Techitama, so-and-so, regarding pending bills, liabilities of MS Tama Fabrications, which is self-explanatory, copy enclosed pertaining to the Dermuk division, PWD, Dermuk against the work table is under. You are therefore requested to examine the pending bills of Sri so-and-so and settle the issue at your end. Similarly, the next page, Lordship. Only everything is same, only here also is requested to examine the pending liabilities, bills of so and settle the issue at your end. In reply to our legal notice, what the executive engineer has basically said that although you have asked me to settle the matter, but because of non-placement of fund, I'm unable to do so. And this was what was communicated to me.
Yes, PWD.
Your Lordship, notice may be issued.
We'll issue notice then. Heard Ms. N. Dungan, learned counsel for the petitioner, who submits that the petitioner is aggrieved for non-clearance of the admitted liability by the respondent PWD authorities. Which according to the petitioner amounts to rupees 97,60, 92,414.87. To stop, the learned counsel submits that the amount due is towards 4 different works undertaken and completed by the petitioner. To stop, she submits that several demands are to the respondent authorities, and that although the respondent authorities have not denied the amount that is due to the petitioner, but according to them, payment could not be made due to non-placement of the required fund. Stuff in view of above, issue notice of motion returnable by 4 weeks. Ms. Arbasar, Lena, Government Advocate, accepts notice on behalf of all the respondents.
Yes.
Petitioner to furnish requisite extra copies of the writ petition to the learned Government Advocate within 2 working days. List the matter again after 4 weeks. Pendency of the writ petition shall not be a bar for the respondents to clear the amount due to the petition. Yes.
Obliged.
Wait, Joseph, my lord, this is a land compensation matter, no? Land compensation matter. So, my lord, for the project, the Italian hydroelectric power project, capacity around 3097 megawatt. And the petitioners are, they are the inhabitant of that area. And once the electric power corporation starts functioning, it will submerge the entire area, my lord. So for that, the government of Arunachal Pradesh has issued a notice, my lord, annexure 2, my lord. So for payment objection for the area, it was done before the deputy commissioner, madam. So the petitioner's area falls in serial number 24, 23 and 24, madam. Page. And the type copy is that, first copy is not readable, madam. Is page number 29. 29, madam. Serial number in the right and left side, 23, 24.
What is this list?
Madam?
What is this list about?
This is a boundary about the land, madam. And a
Serial number 2324.
Yes, my lord.
You said serial number 2324.
Yes. So
What?
after hearing
This is a final notification.
and claim and objections, my lord.
This is under the 1894 Act. Hmm? Acquisition is under the 1894
my
Act.
Yes.
How come? How come? When was it done? The 2013 Act is not applicable in the state of Arunachal Pradesh.
It is applicable, man.
Then why they are using this 1894? When was it acquired?
It was acquired, my lord, on
Which year?
2012, my lord.
Or before the 2013 Act came into?
Yes.
Then-
Final notification was issued, my lord. Issued by the Secretary Land Management.
Where is that?
My lord,
Page-
page number 30. Kappa Holi IS Secretary Land Management, Government of Arunachal Pradesh, my lord. So, my lord, after hearing the claim and objections, my lord, it was settled. And thereafter, some rival group appeared and they same name. And for that, my lord, there was a complaint and counter complaint, my lord, annexation 3 to 8 onwards, my lord. 3 to 8 onwards, page 31 to last. Before the Deputy Commissioner, my lord.
Where is the assessment? Where is the assessment?
Final assessment, my lord.
Yes.
My lord, final assessment they have not issued because it is voluminous. It is voluminous, my lord.
No. What you're claiming here is compensation, isn't it?
Yes, ma'am.
This is only one person here before the court. One individual.
There are 4 persons.
Oh, there are 4
4
persons.
persons.
Okay.
They are from the same clan.
Same clan means that's serial number 23 and 24.
Yes, ma'am.
Ichan Lee.
Ichan.
So your name of the clan appears in the final notification.
Mine.
Then what happened? It has not been finalized.
Not yet finalized, but
Why?
there because of the minor some complaint
Complaint
and
by
counter complaint, man.
Complaint by whom?
Complaint by the other group, that is serial number 17, man.
Serial number 17. Oh.
Minor.
Where's serial number 17?
Page number 28, minor.
Page 29, I think. 17.
29, minor. 17.
29.
Allow Imlu village.
Where's the Hindu village?
Down below, man. 18. 17 and 18.
So a complaint is there from Allow and Imuli.
Yes, ma'am.
But a channel is different. What is all this confusion? I understand.
Within the same area, madam. Suppose for here in UPA, then next is another village is the Tigdo. So that area covers the entire periphery of that hydropower, electric power generation.
See, your case is that the Italian hydroelectric power project.
Madam.
This has been established to generate electricity, and now this is going to affect your land.
Yes, madam.
It will be submerged.
Yes.
It is going to be submergible.
Yes.
So for that reason, the authorities have made the acquisition.
Yes.
As per the final notification, the name of your clan, is it?
Yes.
Or the name of the petitioner?
My clan.
Clan. So the petitioners, they represent the clan?
Yes.
4 of them?
Yes.
How many people are there in the clan? How have you represented the clan? In what manner? It's not
here, my lord, 4 persons are representing.
They are in their personal capacity. It doesn't say that on behalf of this clan or that clan. Hmm.
This is comprising matter of the village area.
So on the basis of final notification that is not prepared till now.
Already prepared, but we applied for the RTI, but it was not given, madam, because it's voluminous. For entire area of the your three, four circles are covered.
No, I fail to understand what exactly is your case.
My exactly case is minor. They are the affected land affected people of that area, and
So if you are affected by that, what do you call establishment of the hydroelectric power project, definitely the authorities would have called for a public hearing. They'll call for a public hearing and hear.
It was heard, madam.
It was heard.
Yes, ma'am.
So where are you in that public hearing? You were not you did not participate.
We have participated in yeah.
This serial number 23 and 24, it is not in your name. It is the name of a village.
Name of a village, madam.
Yes. How do you represent the village?
But they have authorized.
Huh?
They have authorized to file.
How they have authorized you? Where is the document authorizing you? From Echanli, there are only 4 petitioners who have come. Where about? There are only 4 people living in that village.
Page number, minor, annexure 9, page 43, minor. Authority letter.
Only 4 persons, this also.
Yes.
Who are these 4 persons?
They are from the same village, man.
So, petitioners 4 in numbers are from that village.
Yes.
Authorized by another 4 persons, total 8 people. Only 8 persons are living in that village.
No, I have no idea that.
Now, how do you make out your case? I fail to understand.
The minor fact of the case is minor. They have approached before the deputy commissioner, minor.
How?
By way of minor filing the objections, minor. Annexure 3, page 31, minor.
31.
Before the deputy commissioner, minor, on 4th March 2013, objection on intention of issue of LPC against Chai village.
So what is this objection on against the issuance of LPC?
And for that,
this is not a claim for compensation. You are filing objection. That's all.
For land minor LPC. And secondly, minor kindly turn to minor page 33, minor. And 4, minor.
What is this?
Subject appraisement regarding absolute ownership of land located at Chai village under Italian circle of Dibang Valley district, minor. Subject our objection letter dated 4th March 2023, 13.
So I think remedy lies elsewhere. How do you file a writ petition like that? If you are aggrieved with such kind of
All the complaints are pending before the deputy commissioner. So a direction may be issued to the deputy commissioner to resolve the issues, minor.
How to issue a direction? You have not even properly, formulated your writ petition. This is the problem, you see.
My lord, can I please pay 42, my lord? Annexure B 41 to 42, my lord. This is the letter issued by the Secretary, Land Management, Government of Arunachal Pradesh.
See, now here again 2013 Act has been mentioned. So what does it mean? Mr. Som, I
My
think
lord, remit lies because by the all pending complaints are pending before Deputy Commissioner. So Deputy Commissioner is not issuing any order as on today, man.
Yes, what is this case? Anyone? Mr. Kandu?
My lord, I have not been furnished with a copy, my lord, but I just
Yes.
taken the copy of document. My lord, in fact, this writ petition seems to be misconceived, my lord. Firstly, on the point that my lord, petitioner, my lord, in the last page, my lord, these 4 persons, my lord, they all are the petitioner, my lord, in this writ petition, my lord. Last page, lecture 9, my lord. These are the person, my lord, who is authorized
To file the affidavit.
the writ petitioner, my lord. My lord, the writ petitioners are same, my lord. These people are authorizing themselves to represent the case before this is not for my lord, my writ petition, my lord. Writ petitioner, my lord.
No, they are authorizing petition number 1.
Petition number 1.
This is just for swearing, might be for
Affidavit.
swearing affidavit, my lord, but my lord, for representing the entire community, my lord, it has to be, my lord, authorized by the.
Petitioner number 1 has authorized himself.
Yes, my lord. Yes,
That is petition numbers 2, 3 and 4 have authorized petition number 1.
My lord, they are same, my lord.
Petition number 1 also has authorized himself.
Yes, my lord. Petition number 4 is, my lord, by Rondo, my lord. And in the authority letter, my lord, at serial number 4, my lord, is by Rondo, my lord. At page number 43, my lord.
Anyway, whatever the case may be, see, what is the issue here? Some sort of a hydroelectric power plant project has been designed to be established in this area. Some portion of the land will be submerged, and for which land has to be acquired.
My lord.
Petitioners, they say that they are also interested persons to get the compensation.
My lord, as projected by the petitioner, my lord, it is observed that, my lord, they have participated in the hearing of the objection. And, my lord, firstly, my lord, whether the issue, my lord, to be decided, firstly, would be that, my lord, whether they have the proper authority from the village community, my lord. And, my lord, moreover, my lord, petitioner is not able to show any document that they are being affected, my lord. They will be affected by this project, my lord. And, my lord, even the prayer, my lord, prayer number B and C, my lord, it is contradictory to each other, my lord. In prayer number B, it says, my lord, prayer number A, my lord, to direct the respondent number 3, my lord, his deputy commissioner, to keep ABS withhold the disbursement of land compensation amounts in serial number 23 and 24 till final disposal of the case pending before the respondent number 3. Now, my lord, may kindly come to prayer number B, my lord. To pass any other order or orders directing the respondent number 3 not to disturb the disbursement, my lord. In a prayer number A, he says, disbursement of the compensation should be put to halt, my lord, till the of this writ petition, my lord. And at prayer number B, my lord, petitioner is seeking direction for not disturbing the disbursement of land compensation at serial number 23 and 24, my lord, without leave of this honorable.
Yes, Mr. Som, he's
My-
right.
I am very much confused, my lord.
Well, some
What exactly
typographical
really-
mistake is.
So petitioners are themselves confused.
Hmm.
They don't know what they want.
Yes, my lord.
I think you think about it and redraft your petition. Because there are no such essential ingredients for this court to understand what your case is about. And as Mr. Kamduk has rightly pointed out, prayer A and B are contradictory to each other. In one hand, you're saying that don't disburse. On the other hand, you say it should be disbursed. Disbursement of the same should not be disturbed.
Why not, I mean, be allowed to take.
You withdraw and file afresh. You formulate your case properly.
Yes.
All right. That's paid for by Mr. Esau. The petition stands dismissed as withdrawn. However, liberty is granted to his petition if so advised. Yes. Mr. Mao?
May I plead your lordship?
Yes.
Well, in this writ petition, my lord, land was acquired for the so-called Lada Sari Frontier Highway. Total area is 123 kilometer, your lordship. And what happened is that after the acquisition, application in our series of representation, one is that there was no proper survey and that was not done by the team. That is our representation. Other is that this award has been purportedly prepared, but then it has not been made available to the petitioners. We have sought for the CTC of the award, but then they are not furnishing. So we are not able to know how much compensation, how much land has been acquired from the petitioner's village. I think I'll just take to the notification.
This is regarding construction of highway.
Highway. This is that's called a frontier highway.
Okay, and
That
then you are the landowners.
We are the landowners.
Whose land
of
has been
some-
affected.
Yes, some of the locations. So location.
Acquisition is done under what provision of law?
It's under LARA Act. 2013.
LARA Act 2013.
Yes.
Now, what is the stage of that acquisition?
Stage, they have prepared the award, but then award, we are seeking that award should be displayed. As per the LARA Act, there is section 37, which talks about it has to be displayed how much area of the petitioner, how much amount has been assessed. Whole detail has to be displayed through the district administration website, or it should be displayed in the office of the deputy commissioner.
Before publication of the award?
Yes.
It should be displayed?
They should be displayed.
That means before finalization?
Yes. But then we are not made available. We have we have filed series of applications, but then they have not made available to us.
Let us see what section 37 you say.
Section 37, yes. Section 37, subclause 1, 2, 3.
They think after finalization.
The awards of collector when to be final?
Whether they have final, but then they have displayed before the deputy committee, we short it for the award. But then that is not complete, your lordship.
Where is the provision for display before finalization?
Yes, 37, your lordship. May see the 37.
Yes, 37 is there. Then.
Yeah, 37, may I read subclause 1. Award shall be filed in the collector's office and shall accept as hereinafter provide the final and conclusive evidence between collector and the person interested, whether they have respectively appeared before the collector or not, of the true area. That's an important true area, market value of the assets attached thereto, solution so determined, and the apportionment of the compensation among the person interested. The petitioner or person interested. Number 2, collector shall give immediate notice of his award to such the person interested who are not present personally or through their representatives when the awards are made. 3, the collectors shall keep open to the public and display a summary of entire proceedings undertaken in the case of acquisition of land, including the amount of compensation awarded to each and individual along with the details of the land finally acquired under this act website created for this purpose.
So thing is that when the award is made final, the collector will display it, that's all.
Yes.
It is not that before making final, they have to first display it. Then make final. It's not like that.
But then they have, when we short for the display, they have display Joseph. They have the display the Joseph, but then they have not available the complete award. It seems that it is a final. Otherwise, they should not have displayed. When we short for that, that is another issue. The second issue is that there was no.
What are you saying? Just repeat again.
When we short for the display of the award, they have displayed, but they're not complete award.
They have not?
Not complete award.
Okay. So you have filed an application.
We have filed applications. We
Give
have
us the
filed.
complete award.
Yes.
Where is the application?
Yes, my lord. Joseph may see the application is Joseph may see. It's page 95. 95. So let's see the page 95. 95, may I read subject? Request for the CTC copy of awarded compensation information under such and such act to the 4 package. There is a 5 package. In our case comes under the 5 package of Lada Sarli Frontier Highway roads. Another application you'll also see is page 97. So this application was filed on 17/2/2025, and another application which was filed on the 97 is filed on 24/02/2025.
No, stick to page 95 first.
Yes.
The second paragraph.
Yes.
Say in accordance with, please read that.
Yes. We kindly request details information regarding the changes, numbers, and the specific of compensation awarded. Yes. Your prompt adherence to the RS LARO Act in this matter is greatly appreciated.
No, in accordance with, read that one.
Yes. So in our prayer, that is in our prayer, my lord. The prayer.
Read this sentence in accordance with page 95, the second last paragraph.
Second, okay. In accordance with the fair compensation such and such, we invoke such and such for process for determining fair compensation as well as section 21. We require public hearing. This was in fact we have also serious allegation before the compensation was determined. The allegation was that there was no notice to the interested person. That is section 21. Section 21 talks about the notice to the interested person that was not served. And second 27 talks about the compensation has to be determined as per the market value. So this all were not done. So that's how the petitioner, they have been filing series of complaint saying that you are not following the LARO Act and even you are not serving us the award which you have determined. So that's what we are seeking, that award should be made available to us so that we can know how much compensation has been assessed in our name. That will include the award will be under Schedule 1 of the LARO Act. So in that includes land rates, assets and fixed assets, solution, multiplication factors. This all has to be included in the award. And your lordship may see also notification which they have issued, as if this is the section. This was in. May I just take to the page 31. Page 31 also talks about that this is a award notification which they have issued on 11 October 2024. This is page 31. May I just see the notification is 11 October 2024. Award under section 23 of right to fair compensation.
Yes.
Yep. This award, but then it doesn't. Your lordship may see the list of the landowners. I may just take to the page 34. May I just show the column 1, name, village, page 34.
Yes.
Residential, how much area, change number, but then there is no compensation amount. How much they have been assessed. There is no, description of the compensation. Whereas as with this notification, it clearly says that this is the award under section 23 of the right to fair compensation.
It says area in square meters, that's all.
Yes, only
Changes and all that.
the areas, total areas. So that's what we are seeking, that that award should be made available to us, so that if necessary, even the Latter Act, section 64 is there. If I'm not, if I'm agreed with the award, then I can invoke section 64, filing a reference before the reference authority. But unless we are made available the award, it's difficult to go. Unless we know the
Section 64 is paramateria to section the old act.
yes, yes, new act.
Now, what does the section 23 provide for? This is the final award.
Section 23, you may see.
This is basically the area only, isn't it? 23.
23, yes. So section 23 talks about inquiry and land acquisition award by collector.
Please read on the day so fixed.
Yes. On the day so fixed or any other date to which the inquiry has been adjourned, the collector shall proceed to the objection. This is the objection. That's what, yes, I may complete this one. Objection, if any, which any person interested has stated pursuant to the notice given under section 21. But in our case, a notice was also not given to the measurement made under section 20 and into the value of the land at the rate of a publication of the notification into the respective interest of the person claiming compensation, rehabilitation, settlement shall make an award under his land of true area of the land. That is one. B, compensation determined. That's important. You also may see B, compensation determined under section 27, along with rehabilitation, resettlement award are determined under section 31, and which in his opinion would be allowed for the land. And C, the apportionment of the said compensation among all the persons known or believed to be interested in the land, whom or whose claim he has information whether or not they have respectively appeared before him. So there has to be a detailed description of land, area, and amount determined under section 27.
Description and area is there.
Description area is there.
Only thing the amount
is not there. Yes, yes.
Now, section 27 speaks about the amount. Section 27 has been followed.
Section 27, a collector having determined the market value of land required on the calculated total amount to be paid to the landowners whose land has been acquired by the including all asset attached to the land. So section this can be only this section can be only used when the deputy commissioner determines the land, the value of the land has to be determined under section 27. But the section 23 talks about it has to be displayed. Before that, notice has to be issued to the interested parties. But in our case, notice also not issued, and then it has to be displayed before the deputy commissioner's office, so that if there is any claim and objections, because maybe my lane is 100 square meter, so they might have shown as a 50 square meter. So I will say that this is my objection. Objection can be before a deputy commissioner, and the deputy commissioner has to hear the matters. But unless that is not clear in the which is being displayed by the deputy commissioner, so it's difficult to know my total area and then amount, how much they have determined. So that is things. So in this our read petition, we are praying that award should be made furnished to us. That is the prayer in our read petition. Yes, sir. Or it should be displayed in the website of the deputy commissioner. But we have not paid that one. We are just only seeking that we should be furnished the awards.
Mr. Nabam,
My lord.
you have any instructions on this?
My lord, this is for the first time, my lord, Moses. So,
Whether any award has been made regarding the compensation amount, whether it has been quantified or not,
my lord,
it is not discernible in this notification.
correct, my lord.
Only the area and the location is given.
may I just take your lordship, my lord, page 31, which my brothers relied, my lord. This is the notification dated 11 October 2024. My lord, this is regarding pertaining to award under section 23. If you then comes to page 33, something is given here, my lord. Page 33, my lord. Page lordship, my lord. Summary of award, my lord.
No, yes.
Yes, madam. The summary award, the award is summarized under so and so, value of total area of land to be acquired, amount so and so, value of standing asset on land so and so, 100% solution on value of the land and assets so and so, interest amount so and so at the rate of 12%, other established so and so, grant total is something 31 crore, something like that. Now, what, my lord, it has an annexure A, my lord, which is missing here, my lord. Next, my lord, if you lordship that table, my lord, is coming at us as annexure A. This is the total hectares of land, so and so. Now this annexure is missing. I believe, my lord, this annexure may be, my lord, the award, the name of the beneficiary. Why I am saying, my lord, the reason is very simple, my lord. The lordship turns to page 34. This Arunachal Pradesh extraordinary October 18. This is not tally with the notification of 11 October 2024, my lord. That are different, my lord. So I believe, my lord, this is not the annexure A, my lord. If your lordship see the gazette notification, my lord,
No,
that's a different, my lord.
no, that's correct. But the thing is that, see, the gazette is dated 18 October.
Correct,
Notification is of 11th October,
my lord.
but it has been put in the gazette on 18 October.
My lord, your lordship is correct, my lord. On top of, your lordship is absolutely
So
correct.
there's
I'm sorry,
nothing
my lord.
wrong
Your
there.
lordship is absolutely correct, my lord. On top of is written on Friday, October 18, 2024. Your lordship will be absolutely
Now
correct.
we are concerned with East Coming District.
My lord.
Or what? Mr. Mao?
Yes,
We are concerned with East Coming District.
yes, East Coming District.
Plot number survey is annexure A. Area is also name of the registered holder occupy is also annexure A.
Yes.
But everything is given except
Now,
the amount, my lord.
in this survey, will they not include the amount? This much area multiplied by this much.
Yes, they should have included. Yes,
But what you're given here is only just the area.
just area.
What is this annexure otherwise?
My lord, that my lord instruction I have to take what annexure A is about, my lord. Then another issue, my lord, now total acquisition area is, my lord, 132.5 kilometers, this area, my lord. Now, out of this area, how many area falls under the petitioners, my lord, that they have not disclosed, my lord? That under this kilometer, my lord, these are my areas, my lord, that has been taken by the government, my lord. They have not spelled it out, my lord. There are 12 petitioners, my lord. Out of 12 petitioners, my lord, we don't know, my lord, how many square kilometer or what exactly land has been taken by the this district administration, my lord. They have not spelled it out. So far, my lord, section 37, my lord, not disputed, is a total law, my lord. Yes, my lord. Once there is a finalization of award, that has to be notified. That is understood. Because I checked up, my lord, there is no whisper about that, my lord. How many areas, my lord, of the petition has been taken by the district administration? And what is their claim amount, my lord? There is no any statement about that.
No, they say that they are not aware about the amount. That's why.
My lord, it is because of their complaint, my lord. Re-survey was done, my lord.
Sorry?
Re-survey was done because of their insistence, my lord.
No, that's correct. But the thing is that how much has been assessed, that is not known. That's why. How much amount has been earmarked for them?
They have to, my lord, clarify the extent, my lord. This much of area has been taken, my lord. Even they don't know, my lord. That's why, my lord, they have not made any category statement, my lord. There are 12 petitioners, my lord. We don't know, my lord. And so far, my lord, re-verification, my lord, that was carried out, my lord. They have admitted, my lord, it was carried out, my lord.
What exactly is your prayer here, Mr. Mao?
My prayer is that that award which they have advised should be furnished to us. Your Lordship may see the award of my prayer, Your Lordship. My prayer has only one is for the Your Lordship. We are seeking that the respondent for Deputy Commissioner to furnish the complete compensation award of bill so made with regards to 123.5 kilometer of Sada Lada Sadli Frontier Highway project. That is one. Second, what we are seeking is that for the B, for comprehensive physical on grounds re-verification of affected land and properties by the assessment board members. And then third, we are seeking that we have filed series of representation and we have put lots of grievances in the representation, is in C18. But then that representation also still pending.
What do you mean by resurvey?
Resurvey, in fact, what happened was we in our representation, we have alleged that the compensation, property compensation which they have determined, it was done by only one man, only the mandal, without the board members. The board member has to be from a different forest department, horticulture department, land department. But in our grievances in our representation, what we have said is that it is done by the only mandal who is from the land department. And there are also many other complaints from the other land owners also. That is also the, but then I'm confined to my complaint.
There are some representations pending.
Yes.
Perhaps
this can be considered and disposed of. Otherwise, Mr. Nabam.
That can be done if your lordship paragraph 7. Admittedly, they have accepted, my lord. The notice was issued for re-verification, my lord. If your lordship see, my lord, what exactly they are saying, like individually they have been not informed, my lord. But public notice is public notice, my lord.
Yes.
They were admitted, my lord.
Interested person has to be, because it's a big area, especially it's a big area, and then
if you lordship see, page 93, my lord, this is the NHR 4, my lord, this is a public notice.
Public notice, you'll also say it's a small villages, it's a interior villages. Displaying in a deputy commissioner office cannot be construed as a notice to all the villages.
No, it was well informed to all the Gangburas, malab, through Gangburas. Yes, malab.
That is what is done in the villages.
Yes. Gangburas, they are the representative of the village. Your lordship can either dispose of directly the deputy dispose of the representation, or my lord simply notice may be issued, my lord.
Yes.
What is the come up with legal affidavit, my lord.
It's okay, then, your lordship.
Notice. What?
Representation can be disposed of.
Which representation? There are so many of them.
Yes. I think I will take to the latest representation. Your lordship may see the
page 107.
107.
The reminder letter.
Uh, 102 is there.
Again, this is also a reminder. 97 was a reminder.
Yes, you also.
Where's the first one?
First one.
It should be 23rd September 2024. Page 22, my lord, next 2 months. This will be the
page 22, I think.
Page 22.
Page 25 also there.
Representation. This is the one.
Page 22 is our representation, my lords, is page 25. Page 25.
This address to the secretary, correct? Who will consider deputy commissioner or secretary or director?
Deputy commissioner. Deputy commissioner. That's it.
Here you have addressed all three of them.
All three, mother. All.
Yes. You'll also be direct to the deputy commissioner. I think deputy commissioner is respond number. Respond number.
Okay, please.
4.
Third, Ms. Mao, learned counsel for the petitioners. Mr. R.H. Nabam, learned additional advocate general. Mr. D. Kamdu, learned standing counsel, Land Management Department. Stop having regard to the nature of the grievance projected by the petitioners, the writ petition is taken up for disposal at the motion stage itself. Stop next para. It is the case of the petitioners that the authorities initiated the process of acquisition of land for construction of 123.5 kilometers LADA capital LADA dash Sarli 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 Frontier Highway, comma PWD bracket open highway zone close bracket no Frontier Highway. Okay, there is, then after highway you just put, and the state PWD, you continue, highway zone, Government of Arunachal Pradesh being the executive agency, wide notification dated 11/10/2024. Stop. Land with an area of 348.865 hectares situated in villages falling under Bumming and Chayang Tajo Circle, East Kamang district, have been sought to be acquired. By invoking the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013, open bracket, Act of 2013, bracket, to stop. Stop. The petitioners, who are 12 in numbers, contend that they are covered by package number 5, open bracket, Jayang Bagang and Kase Bagang villages, close bracket, in connection with the said Frontier Highway project. Stop. According to them, there are certain irregularities committed in the process of the land acquisition, since survey was not done by the competent authorities, but done only by which one? Only by the Mandal.
And the issue was that not on physical verification was not done. That was the main allegation.
Involving any other departments or agencies. Stop. Moreover, such verification was done on the table and not by going to the spot. Stop. However, the Arunachal Pradesh in the Department of Land Management and before the Deputy Commissioner, Public District Collector, East Kameng SEPA, issued a notification under Section 23 of the Act of 2013. Without mentioning the amount of compensation entitled to each of the individuals whose land has been affected. According to the petitioners, the same is the prescription of the provisions of the Act of 2000, and without which the petitioners are in no position to raise their objections or protests. Stop. The petitioners therefore submitted their first representation before the Deputy Commissioner, East Kameng District, SEPA, on 23/9/2024, bracket annexure 2. Seeking resurvey and reassess the land to be affected by the construction of the frontier highway. Stop. Since the representation remained unattended, the petitioners thereafter filed another representation on 10/2/2025 by addressing this to the Secretary Land Management Department, the Director Land Management Department, and the Deputy Commissioner, East Kameng District, SEPA. Stop. Despite resubmission of the representation, the petitioners, their representation remained unconsidered.
Well, we have filed in the 97th page also, there is 2-3 representations.
I'll take that into account.
Page 97.
Don't worry, Mr. Mo. What did I say? Unconsidered, and therefore the petitioners submitted reminders to their representation on 17/2/2025, 24/2/2025, and 4/3/2025. Stop. Since they have not received any reply from the respondent authorities concerned, they are before this court. To stop. Considering the fact that the petitioners have raised their grievances in detail in their representation dated 10/2/2025, this court is of the view that instead of keeping the writ petition pending before this court, the same should be considered by the Deputy Commissioner, East Kameng District, SEPA, since it is the state authority who has undertaken the exercise of acquisition of the land in question. Stop accordingly. The writ petition is disposed of by directing the Deputy Commissioner, East Kamen District, SEPA, to consider the petition submitted by the petitioners on 10/2/2025 and the subsequent reminders. And to pass a reasoned and speaking order. Stop. It is also provided herein that Mr. Nabam, should they be heard? Should they be heard? The petitioner's opportunity of hearing?
May not be required, but the whatever matter the prejudicial disposal, that will be communicated to them, either accept or reject it.
The exercise as directed herein above should be undertaken and completed within a period of 6 weeks.
1 month.
1 month.
1 month will be
Within a period of 1 month from the date of receipt of the
Receipt of
certified
the-
copy of this order.
Your Lordship, may I pray that 14 days will be done. Once we submit the certified copy, they can dispose of within 14 days. I will pray that. can be-
30 days is quite reasonable, my lord. 30 days.
Let it be 1 month,
1 month.
Mr. No. The order to be passed by the Deputy Commissioner shall be communicated to the petitioners.
Because this is ongoing, I mean, I think many things are happening, they are not disclosing. So it will be good if representation is disposed early.
No, that will be the burden of the deputy commissioner, my lord, the district collector. Don't worry for that. In the meantime, my lord, as per the section 37, if you disclose the award, my lord, that will answer to your query.
Because they are they are even hesitant to furnish the awards. So if they want to give relief or not relief, if it time frame is short time frame is given, then that will be good.
Okay, we'll make it 3 weeks then, huh?
3 weeks.
Within a period of 3 weeks, not 1 month. All right.
My lord, no issues.
How like?
Yes.
Petitioner is not present.
Ah.
For last two occasions, he is not present.
And you're also not filing counter affidavit.
We are filing, ma'am.
You filed? When? Respondent number 4.
We have filed.
What about others?
Others won't be filing, ma'am. This will do.
What is the issue here?
Pending bills.
What is your stand? No funds.
My lordship. Earlier, one more petition, it was dismissed, my lordship. Similar issue.
Was dismissed?
Yes, ma'am.
Why? How?
It was not maintainable. I have the other.
No, without knowing the facts, how do we apply this to your case?
Similar issue, my lordship, out of same LOC.
No, disputed questions of fact, isn't it?
Yes, ma'am.
Is there any dispute in this case as well?
In our affidavit, we are saying that, kindly come to, page number 6, Manoj, annexure 1. Our affidavit.
Before that, what is the claim?
They're claiming for, Pending bills, my lordship.
Yes, where are the details of the pending bills?
Details of pending bills. The respondent, they were claiming, for a repair of, maintenance of bridge and roads, my lordship. Under the Department of, PWD, Palinkarada district. In total, 89 lakhs, my lordship.
Correct. So where is the detail of their claims? They have not stated.
They have only submitted this LOC, letter of credit, my lordship. Other than that, they don't have any other documents, my lordship. In page number 13, my lordship.
13.
Work-wise LOC demand,
How much is the amount?
89 lakhs.
Where do we get that? 39 lakhs.
Page number 13 of main writ petition.
I'm at page 13, but where's the amount?
Total amount is 39 lakhs. Divided into two forms, my lordship.
Where is the amount?
Down, my lordship. Recommendation of SE. 89. They have only this documents, my lordship. Basing on this document, they were claiming the amount.
Recommendation of SE?
SE scheme. So it was rejected, my lordship. Because we didn't find any other documents. Only this.
No, I have not seen the amount anywhere. This is the thing. I'm asking you the amount.
Page number 13, my lordship. Of their writ petition, main writ petition.
So page number 13, there's nothing there. Where is page number 13? You mark it. You have disputed that amount.
Yes, my lordship. We are saying that other than this LOC, they don't have any other papers, my lordship, to claim their amount.
What is this?
89 lakhs.
So the figure 89 means 89 lakhs.
Yes, my lordship. 47 is claimed by one person and 42 is claimed by other person.
How many petitioners are here?
2 petitions.
They're claiming 47 plus 42.
Yes, my lord. One person is claiming 47 and one person is claiming 42.
These are signatories are your officers only. Divisional accountant, executive engineer,
It was
and superintendent
under pressure.
engineer.
We have stated in our affidavit also that it was done under pressure.
Under pressure.
Yes, my lord.
Who's giving you the pressure? The
The
petitioner.
petitioners, yes, my lord, contractors.
How? How can they give pressure to the department officials? Anyway, we'll do one thing. We'll post it again some other day. So as the petition is not here.
He was not present last 2 occasions also, my lord. He was not present for last 2.
We'll make an observation because supposing we want to dismiss the writ petition, it will not be proper in his absence. Let him come. None appears for the petitioner when the matter is called. Your good name, Miss
K. Wang.
K. Wangmo, learned government advocate, appears for the respondents and submits that counter affidavit has already been filed by the respondent number 4. She submits that by filing this writ petitioners have claimed payment of rupees 89 lakhs, which according to them is for the work they have executed. In repairing and maintenance of roads and bridges. She submits that the amount, however, is disputed by the respondents. since as per their measurement books and other documents, there is no record to establish that the amount claimed by the petitioners is a pending liability. In other words, learned counsel submits that there are highly disputed questions of facts which cannot be adjudicated in a writ before a writ court. She also submits that another writ petition of similar nature, that is WPC number 280 of 2023, was dismissed by this court by order dated 17/6/2024. Next paragraph, be that as it may, since the counsel for the petitioner is not present today, matter stands adjourned for 2 weeks. It is also noticed that when the matter was listed on 29/8/2024 and 10/1/2025, none had appeared for the petitioner. If the same is the situation on the next court date, court may consider passing appropriate order.
Item number 9.
My lord, I'm appearing online, my lord. There is some personal difficulties. I could not reach Itanagar. For that, I apologize, my lord. My lord, the issue here, the subject matter is land acquisition of land compensation, my lord. The subject matter, my lord. And the issue here, my lord, there are certain few issues that are framed, my lord. If my lord may be pleased to come to paragraph number 5 of my writ petition, there's some issues that are framed, my lord. And I would like to canvass on these issues, my lord. My lord, has it paragraph 5?
Yes. Yes.
Yeah. So my lord, the first issue was whether the district collector Rowing was right in directing the petitioner to approach the civil court for declaration of right to receive the compensation instead of making reference to the authority under section 64 of the Right to Fair Compensation Act of 2013, my lord. Here, my lord, kindly look, there was a preliminary notifications, my lord, for acquisitions of land, of my clan's land, my lord, for setting up of the Dibang multi-purpose hydroelectric project, my lord. So, my lord, having come to know that another member of the other clans have submitted their project affected list, people's list, my lord, I file an representation before the deputy commissioner, my lord, and the complaint filed before the deputy commissioner, my lord, will find at page number 100, my lord, of my writ petition.
Yes.
May I just read, my lord?
See, before you go further.
Yes, my lord.
Now, question is, are you going to file any rejoinder or reply affidavit?
My lord, I just forgot to make a mention before my lord also that the private respondent number 4 and 5 are yet to file their counters, my lord, in this case. So, my lord, I thought today was an admission hearing. So, otherwise, I am not very much aware of the procedure of the practice there. If my lord permits me, I will wish to file the rejoinder to this affidavit, my lord.
4 and 5 have not filed their counter affidavit.
No, my lord, they have not yet filed.
Why are they made a party here?
My lord, they are the members of the clan who have received the compensation in my place.
Okay, you are raising a dispute about the compensation received by respondent numbers 4 and 5.
Yes, exactly, my lord. Yes, my lord.
Anyone present for 4 and 5?
My lord, as said, my lord, service is not yet complete, my lord.
Not yet complete.
Not yet complete, my lord. That's what my friend was saying, my lord.
Oh, so these
Because
are
of
the
that.
few factors which has to be accounted for.
My lord, my lord.
But when
My lord, I believe that's. I was informed by my associates that they have filed Vakalanama. If I subject to the corrections, my lord, they have filed a Vakalanama, and one occasion they might have appeared also. Subject to the corrections, my lord.
4 and 5.
4 and 5, my lord.
But there is nothing indicated in the.
My lord, may I pray, my lord, instead of wasting my lord's time, then give me some time, my lord. I'll just take proper instructions, my lord, and do the needful.
How much time should you require for filing rejoinder?
Rejoinder, my lord, 3 weeks, my lord.
All right. As paid for by the learned counsel for the petitioner through VC. Further 3 weeks time is granted for filing rejoinder affidavit. To the affidavit in the position filed by the respondent numbers 1, 2, and 3, correct?
Respondent number 3 only has filed, my lord.
Only 3 is filed.
Only 3 has filed, my lord. As per my.
My lord, the affidavit filed by the respondent number 3 will cover respondent number 1 also, my lord.
Okay.
Because that's a deputy commissioner.
Just let's say respondent number 3, not 1 and 2. Okay, respondent number 3.
Yes.
Then it is also seen that there are 2 private respondents, namely respondent numbers 4 and 5. Office to put up a note regarding service of notice to them. List again after 3 weeks.
My lord.
Yes.
Deeply obliged.
Number 13.
Just 13, yes.
My lord, instructions have been received that the departmental proceeding is complete, your lordship. However, we are yet to receive a final order.
What have you challenged here?
The petitioner is aggrieved by the action of the respondent authorities in not conducting the departmental proceeding in terms of the guidelines laid down by the Honorable Supreme Court, your lordship. However, in the meantime, it has been learned that the departmental proceeding is complete. However, the final order is yet to be received by the petitioner, your lord.
Yes.
On 27 February, I have produced the instruction that DP has been concluded, your lordship. And only a decision has to be taken.
So when is the decision going to be taken? You want some time?
No, your lordship. So
You don't want time?
I have filed my affidavit also, and we have produced the instructions, your lordship, that DP has been concluded, your lordship. He's aggrieved that DP was not initiated.
So where is that instruction which says that it's concluded?
27 to 25, your lordship.
Sorry?
27 to 25. I've produced the instruction. Dated 3rd February, your lordship. Letter dated 3rd February 25.
It's concluded, but it says that, however, the matter is still pending for final decision.
Yeah, for decision it is pending, but
So-
DP has been concluded.
And you are under suspension or not suspended?
I beg your lord. I beg your pardon.
Are you under suspension or
Yes, your
you are serving?
No, I was under suspension, your lordship.
Was
I am still under suspension.
you are still under suspension?
Yes, sir. Oh, I'm sorry, your lordship. No,
So then can the matter be closed then?
Yes,
Your
Your
Lordship.
Lordship.
If what you want prayer was thing. We'll close it.
Yes, Your Lordship.
Yes.
Written order, Your Lordship, if Your Lordship obliges an order to the respondent authorities to issue the final order within a time frame, Your Lordship.
How much time frame?
2 months, Your Lordship. Within 2 months.
My lord, since the order it has been departmental proceeding was completed way back in the month of February, Your Lordship. A period of 1 month may be given, Your Lordship.
Okay. But Miss D. Tamuk and Miss R. Basar, Miss D. Tamuk, learned counsel for the petitioner, and Miss R. Basar, learned senior government advocate for the respondents. By filing this writ petition, the petitioner has sought for setting aside and quashing the memorandum dated 2/8/2023 issued by the Superintendent of Police, West Kameng District, Bomdila, by which department proceedings was initiated against him or her,
Him, Your Lordship.
against him. To stop in the alternative, the petitioner has also prayed for a direction to complete the departmental proceedings in terms of the guidelines laid down by the Honorable Apex Court in Premnath Bali versus Registrar, High Court of Delhi, 2015-16 SEC 415. Stop. Next para. During the pendency of this writ petition, the court has been informed that the departmental proceedings against the petitioner has been concluded. But however, the matter is still pending for final decision. Stop. Such submission was made to the court on 27/2/2025. Stop. Today, Ms. R. Basar, learned senior government advocate, submits that it is only within a matter of time that final decision will be taken by the competent authority, since the departmental inquiry against the petitioner has already been concluded. Stop. Considering the submissions made and upon hearing the parties, the writ petition is disposed of. With a direction that the respondent authorities concerned shall take a decision in the matter since the department inquiry is said to have been concluded, as expeditiously as possible and in accordance with law. And how much time?
2 months, Lordship.
Have 2 months.
My lord, can it be a period of 1 month, your lordship, since
Sorry?
can the order be issued within a period of 1 month, your lordship, since there is this
So
matter
there
is-
are formalities to be done. So what to do?
2 months.
Because there are many formalities.
Yes.
They might give you a notice also. You have to reply against the proposed whatever it is. And at any rate, within the outer limit of 2 months from the date of receipt of a copy of this order. All right.
Obligation.
May it please your lordship. This writ petition is directed against an impugn transfer order, my lord. Against a transfer order.
Transfer.
My lord, I was suffering from, my lord, brain stroke, my lord, cerebral stroke, and I had suffered paralysis on my right side. That is why at that time I was working in SEPA. Because of my paralysis, my lord, partial paralysis, I was transferred to Naharlagun. This was on, my lord, 69, sorry, my lord, it was on 11/22. Thereafter, my lord, in 23rd of September 2023, my lord, the impugn transfer order was issued, transferring me from Naharlagun to Dapurijo. Dapurijo, my lord, does not have so much of medical facilities. I require, when I suffered the stroke, my lord, I had to be taken down to Dibrugarh for my treatment, and I have to undergo regular checkups in Ramakrishna Mission Hospital here, as well as in Dibrugarh. My lord, from Dapurijo to Dibrugarh is too far off, my lord. That is why I had earlier approached lordships by way of a previous petition, my lord, that was disposed of directing consideration of my representation. The representation was of against me, my lord. As against them, against the disposal of the representation, I'm before lordships. My lord, when the matter was initially, notice was issued, my lord, the impugn transfer order was stayed, my lord, and they have filed their affidavits. Today, my lord, if my lord considers the matter for disposal, my lord.
Well,
What do you say?
Council, standing council, he led the premises, Your Honor.
Sorry?
This matter may be adjourned for today, Your Honor.
You're not the case, you're not there in the case.
No, I'm on behalf of Tabatagum. Standing council.
Sir T. Tagum.
Yes, Your Honor.
Standing council?
Health and
Education.
Education.
Education. He's
Yes,
not here today, Mr. Huh?
He left, Your Honor.
He left.
Yes, Your Honor.
The stay order is in my favor, my lord.
And stay will continue then.
My lord.
What to do? When do you want it?
My lord, after 2 weeks or something, then my lord.
2 weeks. You want a date?
After 2 weeks, I think.
Mr. T. Tagum, Learned Standing Council Education Department. What do I record? I record his absence.
No, Your Honor. Due to some urgency, he left the court premises.
He is said to have left the court premises on account of certain personal emergencies. So stop. The prayer has been made on his behalf for adjournment. Stop. Mr. P.D. Nair, counsel for the petitioner, has no objection to the prayer. And therefore, the matter stands adjourned for 2 weeks.
Yes.
Interim order passed earlier shall continue till the next date of listing.
Deeply. May I please, my lord.
Yes.
Yes, my lord, the main issue in this writ petition is caused by the respondent authorities stopping my operation of my stone crusher unit is tenable in the eye of law or not. My lord, in the last occasion, my lord, order dated 27 February. May I kindly peruse, my lord. And this will be the 6th listing of the matter, my lord. from the day one, I've been praying for interim relief. So, my lord, the impugn order which I've challenged is Annexure 2 and 3. My lord, basically, that impugn order has been issued only on the pretext that there is a case pending in the Honorable High Court and another one in the NGT Kolkata. And only on that pretext, my business has been stopped. There is no interim order in any of these.
What case is pending before the High Court?
My lord?
What case is pending before this court?
PIL. Regarding another stone crusher and my stone crusher, my lord. That is why the PIL has also been attached, my lord. In the PIL, already the affidavit by the respondent authorities have been filed, which is in my favor, which clearly records that I have been operating my stone crusher as per the guidelines of the stone crusher.
PIL is against your stone crusher.
Yes.
Against the operation of your stone crusher.
Yes. But there also the respondent authorities are also party, and I am a private respondent in that PIL. So we have already filed our affidavits, and they have also filed their rejoinder, and now PIL is at the stage of admission hearing. So it has not been taken up for long, and in the meanwhile, another complainant, another file this in the same subject matter in NGT Kolkata. So only on that pretext, now the respondent authorities, even my NOC was valid. During my validity, they have passed this impugn order. So today, my lord, today this writ petition is listed for the 6th time.
So what is the status of the NGT?
My lord, that is also on admission stage that some affidavit has to be exchanged.
In such a situation, what can be done?
My lord, I may be protected. My lord, every day I have men and machineries which have been stopped for the last 6 months.
Means you may be allowed to operate your stone crusher.
In the meanwhile, my lord,
That
let
what
them
you say?
come up with a definite affidavit, my lord. Let the respondent authorities file their written affidavit.
No, the thing is that you see the same issue is pending for the NGT. Side by side, it goes here and there. Is been looked into that in the tribunal and as well.
My lord, had there been any prima facie, there has been any illegality. Even this, our Honorable High Court, as well as the NGT would have stopped it by some stay of the operation of my stone crusher unit. But my lord, they might not have found any prima facie illegal activity.
Where is the impugn order?
My lord, impugn order, page number 16 of my writ petition. On the behest of this order, my lord, that concern page number 16 is the order of the respondent.
Dated 21st May.
Yes, my lord. This was addressed to the Assistant Mineral Development Officer of my area. My stone crusher unit is located in Merbo, Pasigat, East Siang. Then, after this order, that on the very next page, Annex 3, that AMDO, Assistant Mineral Development Officer, stop the functioning of my stone crusher under the directive of the secretary. This annexure 2. My lord, in the order itself, it is reflected. There is a notice issued from NGT. There is a pending. No illegality has been mentioned in the order itself, my lord. Now I ask myself whether the pendency of a case will mechanically stop my business when there is no such interim order on those pending matters.
This person who has filed the complaint before the NGT,
my lord,
is he a party in this present case?
No.
Who's the petitioner here?
My lord.
Who's the petitioner?
My lord, this is my proprietor firm, Balaji Mineral Stone Crusher.
Balaji Minerals.
Yes, my lord. It's a proprietorship firm and presented by its proprietor at if my lord may wrote in back then there was another PIL was also filed where it was disposed of with the direction for the concerned deputy commissioner to get an inquiry. That inquiry report also, my lord, I have annexed in this writ petition, in the instant writ petition at annexure 5, page number 22, my lord. There also, I have already undergone 2 inquiry reports where there is nothing illegality have been found. And now suddenly this is the report of annex page number 22, my lord. It's a complete report.
Who are the respondents here?
My lord, respondents are all state authorities, my lord. No private individual.
They have filed counter affidavit?
No, my lord. Kindly see the, my lord, last order, 27 February, my lord. There's a 27 February, my lord. That was the 5th time, my lord.
For instructions?
Yes, my lord. See, instruction have been waited for so long, my lord. At this stage today.
Instructions regarding what?
My lord, in the last paragraph of the last order, dated 27/2/25, it is last paragraph says, it is also made clear that if no such instructions is produced, this court may direct personal appearance of the Secretary, Geology and Mining on the next date fixed to explain his conduct and to clarify the instruction. My lord, I don't have any enmity with the Secretary, but my lord, in the meantime, if the instruction are not there, my lord, I will pray for my interim, at least let me work. This is the working season, my lord. My crusher unit has been stopped for the last 6-7 months. And I cater to more than 30 laborers in a day. Although I don't earn in lakhs, but every day there are thousands of losses since for the last 6-7 months, my lord. That is why, my lord. Let them come up with the proposal.
Since May, is it? Since the month of May.
My lord.
Since the month of May,
yes,
stopped.
my lord, my lord. And then we filed our representation also. We didn't get. Although I am late,
Where
my
is your
lord,
representation?
my lord, representation at annexure 6, page number 28. No, my lord, no, sorry. Annexure 4, page number 18 to 21. Page number 18 to 21. There also I have raised the same issue, my lord. Page number 18, annexure 4. Same explanation I've given, what I've given in this instant writ petition, my lord. We were never given an opportunity to be heard also, my lord. This is a violation of principle of natural justice also, my lord.
Where is that report which is in your favor, according to you?
My lord,
in the PIL.
The report I've annexed is in
the PIL.
Annexure 5.
Of this writ petition?
Yes, page number 22, my lord. This is the report from the concerned DC of the area. page number 22 to it goes up to page number 26, my lord.
Report submitted by whom?
My lord, it was submitted by ADC Pasigar. My lord, may I take your lordship to page number 26? The first paragraph, page number 26. It is type copy is on page number 27.
No.
My lord, I am concerned with Balaji Mineral Stone Crusher. There was complaint against.
Page 22, actually, it begins with report on the top, like that.
Yes. This report was submitted back to the authority also, my lord. The same report.
Where is the reference of the thing? This is order.
My lord, Annexure 6, page number 28. Last page, my lord. This is where the DC has forwarded this report to the Secretary Geology and Mining, respondent number 1. Page number 28, Annexure 6.
No, this is in reference to the PIL.
My lord, after that PIL, this PIL number 3, 2023 has been disposed of. Thereafter, this report has come up on the direction of this honorable court only.
No, if you take this Annexure 5 report,
my lord,
it starts with reference. Where is the forwarding letter?
My lord, this report has been submitted to the DC. This inquiry was done on May, and the same was submitted to the DC, and the DC, that is why on Annexure 6 on 25th July.
No, the report itself does not begin or end anywhere. It doesn't address anybody. It just says report. And who has given this report? Who is the signatory?
My lord, signatory inquiry officer ADC, page number 26. ADC Pasigar. Oli Perme. Page number 26.
How is this?
It's part of the same report, my lord.
No, page 22 is something, and it starts with all this, what do you call, the chart.
Yes, my lord. Chart is of the report, my lord. And then page number, it ends at page number 26. This is what I could procure from from the office.
See, the allegation against you is something else. It says you don't have the environmental clearance. You don't have the NOC from the forest. Do you have all these?
Yes, my lord. That is there in the PIL. That is why PIL has been attached. I have all the clearance. My lord, that is a complaint.
You have the environmental clearance?
Yes, of course, my lord. Otherwise, my lord, I will not be able to set up my stone crusher unit. These are the prerequisites under the Arunachal Pradesh stone crusher guidelines.
So where is that statement in your affidavit, in your writ petition here, that you have all the relevant documents?
My lord, that I have again placed it in my PIL, my lord.
Why do you rely upon PIL?
Why? Because, my lord,
PIL is against you.
No.
It is not your PIL. Is it your PIL?
No, my lord, it is still this is my understanding.
No, the PIL is filed by somebody else.
Yes, my lord.
Against you.
Yes.
This writ petition is filed by you against the stopping of your stone crusher.
My lord.
So the basic ingredients of your writ petition should be that I have all the papers with me. I have all the permission with me. So why has my stone crusher been stopped? This is what you should say. Where have you said that in your writ petition? How you have challenged this?
My lord, my understanding, when the impugn order on the face record, it says only because 2 litigation has been pending against my stone crusher.
All right.
I wanted to focus on that part only.
No,
because
maybe you will say that, but the thing is that you are also to primarily show that you have all the necessary permission to run that stone crusher in that area, which will persuade the court to grant you an interim order if not dispose your writ petition.
My lord, I rely on the report of this DC also, my lord. This is one of my strengths.
Does it say that you have all the required papers?
Yes, because in the last remark it said that that is why, my lord, page number 26. May I read, my lord, the first paragraph, page number 26. Further, MS Balaji Mineral Store Person Memo, that is me in the petitioner, have fulfilled all the parameter, have advised to sprinkle water after every use of machine in and around the crusher area. In the western side, they have covered the fence with long CJs, which is to be uniformly placed around the boundary wall. This is only the suggestion. But here in the very first line, have fulfilled all the parameter. Who have prepared the report? ADC, Additional Deputy Commissioner herself. So, my lord, time after time, some of these people, in a very frank manner, my lord, they have been just creating complaint. They are not even from our village, and their villages very far off. Even my neighbors do not complain. When I got the LPC, whatever, even my village people doesn't complain. The immediate neighbors also don't complain, my lord. So these statements, these submissions, I've already made in my PIL, the pending PIL. More so, my lord, if we look up the affidavit of the respondent authority, respondent number 1 is more specifically, in their adjournment in their affidavit is also in my favor.
You are a respondent in the PIL?
Yes, my lord, private respondent.
Let us see what have you filed any affidavit?
Yes, my lord, very long time ago, my lord, as expected by your lordship, that here I have given everything, all the NOCs, my lord, my affidavit in opposition.
Respondent number 9.
I am respondent number 9 in the PIL, number 17/2023, my lord. Here, my lord, I have given everything, how I procured the trading license, how I got the LPC, how I got the order to run my business, and all the NOCs issued by all the departments.
Let us go through the annexes, page 15.
Page 15, yes, my lord.
This is your trading license?
Yes, my lord. Thereafter, page number 16 is the LPC.
Is there any period specified for running the trading license?
Pardon, my lord?
Is there any period prescribed for running the trading license? Having the trading license?
Validity, my lord, yes.
Validity?
Yes. This is the old trading license. This is
valid
the new trading license in my writ petition, the instant writ. This is from 2021. It is valid up. This license was valid up to 2022. Thereafter, I've renewed it. The renewed one is in the instant writ petition. Anyways, thereafter, my lord, LPC, the prerequisite for any business to establish, you must have your own LPC. Annexure 2. Thereafter, my lord, Annexure 3 is series of NOCs, which is a prerequisite of the Arunachal Pradesh Stone Crusher Guidelines. These are from the Gaon Buras, ADC of the concerned area, Divisional Forest Officer, Assistant Mineral and Development Officer, Deputy Director of Industries, and very important factor is State Pollution Control Board and State Geology and Mining Department. That also I procured. But without this NOC, I won't be able to establish my stone crusher. These are prerequisites.
Where is that pollution and geology?
NOC?
Yes.
My lord.
Geology is page 22.
Page. Yes, my lord.
Pollution control.
Pollution control is somewhere here. Pollution control. I missed it only.
Mr. Nabam, you are there for which respondent?
Yes, my lord.
You're for which respondent?
I'm for respondent number in PL, my lord. Here, my lord, I'm for respondent number 1 to 6, my lord.
What do you say on the interim prayer?
My lord,
Any instructions?
instruction, yes, my lord, we received, but if you rely on the affidavit filed in the public interest litigation, that is 70, which is pending, my lord.
Okay.
Here we have filed, my lord. This, as per paragraph 6, this is the affidavit filed on behalf of the Secretary, Geology and Mining, my lord.
Yes, what do you say?
It says, my lord, they have complied with all the formalities, the petitioners, my lord. So, it says, my lord, the operation of two crusher units was not illegal. So, means, my lord, all the NOCs document, it was totally verified. Having found correct, my lord, so license was issued to them, my lord. So now, if I rely on the affidavit filing public
Hmm.
litigation and the impugned order, these are totally contrast, my lord. Yes.
Contradictory.
Contradictory, my lord. Now, this is the affidavit filed on behalf of Secretary, my lord. Now, which one I should rely on, whether the impugned order or the affidavit filing in the public litigation, my lord?
No, impugned order is issued by whom? Again,
But-
this is also by
It's your that is from the Secretary Mining, mother to the mining officer, my lord.
no
Same.
impugned order is given by the
It's a Secretary, my lord, mining, my lord.
Secretary, man. Respondent number 1 only.
Respondent number one.
secretary.
Yes.
Yes.
On his directive, the respondent number 2 has forwarded.
Stop, my lord,
Stop.
these things.
Who is the additional deputy commissioner?
No, AMDO.
Huh?
Wait.
Oh,
Sorry, my lord.
A-
Respondent number 5 further forwarded the direction.
AMDO. What is AMDO?
Assistant Mineral Development Officer of the area concerned.
I see. So primarily it was the secretary.
Yes, my lord.
And the secretary has filed the affidavit in the
In
PIL.
public litigation, my in paragraph 6, it says, my lord, nothing is wrong, my lord. It's not illegal. So I don't know, my lord, which one is then I should take, my lord. My lord,
Why don't you get it reconciled? What to do?
My lord, it would have been very smooth if my stone crusher was not abruptly stopped. Let the outcome of the PIL as well as the NGT decide the fate of my business, not by such order. That is my humble submission. There was nothing. Even during the pendency of the PIL, I was working. But abruptly, when a notice was issued from NGT Kolkata to respondent number 1, then abruptly, without hearing us, he issued such notice. That is why there is my lord. There were when the difficulty arises. Let everything become the subject outcome of this writ petition or the PIL.
What is the stage of that NGT?
NGT, my lord, it's some of the respondents have not filed their affidavit yet, my lord.
You are also the respondent there?
Yes, my lord. Private respondent.
Private respondent.
Yeah.
State is also a party?
Yes.
yes, my lord.
What does the state say to that?
My lord, that part I have to take instruction, my lord. Now, my lord, in this WPC number 30, my lord, we have received the paragraph comment. My lord, the same ground only. There is a complaint and there is a public litigation pending. It's pending in Green Tribunal. But these are the major grounds, my lord.
Do one thing, why don't you all get the status of the NGT? We'll see. We'll have it again some other day.
NGT,
My lord.
my lord.
Till then, I pray for some interim
No,
protection.
not till then at this stage. You just get some instruction from about the NGT. Then, because this thing is disturbing the court. Parallelly, two things are going.
My lord.
And
Three things, my lord. One is NGT, one is before the division bench, one before single bench, my lord.
division bench is PIL.
Yes, my lord. PL.
But it has been tagged along with this.
Just to understand the
Just
matter.
to understand what is the issue in PL, my lord. For that purpose only it was tagged together, my lord. And I checked the my lord, in PL also, there is no any such observation from the Honorable Court, my lord, debarring the other side to not to operate, my lord. There is no such any injunction or interim order, my lord. Even in my lord, NGT also, there is no such injunction order, my lord.
Anyway, you get the status.
I'll
By
do
the
that.
state.
Yes, my lord.
Is there any case number on the NGT?
NGT, my lord, I have.
Case number?
Yes,
Yes,
it is reflected in the order also, in the impugn order. Page number 16.
There, since you are also a party, government is also a party, I think you can get your.
My lord, this situation would not have arisen had there been not this such peculiar order, my lord. So, my lord, even the applicants or the litigants, nobody is suffering. Only I am the one who is suffering with this kind of orders, my lord. So then I'm praying for interim order, my lord. Instruction after instruction. It's been almost 7 months, and now March being the month of business, my lord. When do I work? Should I keep on waiting for their instruction, their affidavit for all this while, my lord? When in their own affidavit, they're in my favor, my lord. Had there been any environment pollution, whatever, even the DC report, my lord.
Yes, Mr. Counsel, I understand. See, I have indicated my mind. So when can you get the instruction? Regarding the pendency of regarding the status of that thing, NGT. What has happened? Who has filed the affidavit? Any further orders have been passed? Or what is the status? From the court.
My lord, it will take another at least 4 weeks, my lord.
Why?
And because.
Why? I'm not talking about 4 weeks. You can't get the information within the next 2-3 days. You are a party there, isn't it?
My lord.
You mobilize your resource and say what has happened to that case. Mr. Nabam also will.
My lord, I'll
can
try
able
to
find
get
out.
it from the, my lord, geology or mining department, my lord.
Geology, yes.
Geology and mining department. Obviously, there will be
They're-
party and also my lord, forest department,
They're basically one phone call away, that's all.
my lord. So
Just
can
call
it
up
be
and find
listed
out
on
what
my
has
lord, Monday, what? Thursday, my lord? Thursday? This Thursday, my lord. Today is Monday, so we have another 3 days.
Thursday might be some problem.
Friday, my lord, Thursday or Friday?
Friday is not.
Friday will be the last
It's
one.
a holiday.
Yeah,
Friday.
my lord, yes.
It's holy.
So,
And then again, my lord, the bench will change, and then I have to plead again, my lord. Again, instruction will. This is my lord. Lordship, my lordship is 4th or 5th day, my lord. Keep on changing instruction, my lord. That is why, man. That is the difficulty, man. Another bench will come again. I have to explain again. And
So like I said, had it been solely a case pending before this court, whether single bench or division bench, there have been different. Since some other proceeding is going on, that's why one has to take into account that aspect also.
so my lord, can it listed on Wednesday, my lord? In the meantime, I'll try to take instruction, my lord.
Wednesday?
Wednesday, my lord.
Wednesday?
My lord. Sir, I'm forgetting it.
Any other party not represented today? Is basically between the state, yourself and the.
Yes, my lord. All officers.
Now, who are the respondents here? They're all officials. Nabam will represent all of them. Okay. Please write down. Parties are represented by the respective councils. So, grievance of the petitioner.
Standing counsel for
Is that
standing counsel for petitioner.
why the immunication dated 21/5/2024 and the order dated 4/6/2024, comma, the petitioner has been prevented from operating the stone crusher.
Sir, hey, Julie, mining होना चाहिए.
Where is it located, stone crusher?
My lord, Merbo Pasigat. Merbo East Siang District, Pasigat.
Located in Mebo, East Siang District. So it is seen that PIL number 17 of 2023 has been filed against the operation of the stone crusher by the writ petitioner. And likewise, OA number 10 of 2024 / EZ. EZ means E-zone. EZ is also filed before the National Green Tribunal at Kolkata against the stone crushing unit of the petitioner. To stop, it is due to the pendency of original application before the National Green Tribunal and the PIL that the impugn orders have been issued. Stop the learned counsel for the petitioner. Submits that pending further proceedings in the matter, the petitioner may be allowed to operate the stone crusher. Stop considering the said prayer. Let the matter be listed again on 12th of March. On which date the learned counsel, petitioner, and as well as the Mr. R. Nawam, learned additional AG, shall inform the court about the status of the OA said to be pending before the National Green Tribunal, Kolkata. Okay.
Obliged. Lordship.
This is listed for orders. Yes.
Your Lordship, we are praying for adjournment today, Your Lordship, with the consent of both the parties.
Who's for the other side? Mr. Sarkis, you're there. File rejoinder affidavit or not?
Lordship.
I have nothing to do with anything about
When do you want it?
18th. The conducting counsel will appear personally on 18th. Mr. P.K. Tiwari, Lordship. For respondent number 2, NHPC.
The prayer for adjournment has been sought on behalf of Mr. P.K. Tiwari, learned senior counsel, appearing for respondent numbers 2 and 3. What did I say? This week. to the effect that he has some personal difficulties to conduct the case today. And that the matter may be listed again on 18th of March 2020.
18th, Your Lordship.
Huh?
18th of this month.
18th of March, that's what I say. Listed again on 18th of March 2025. Stop. The said prayer is not opposed to by the learned counsel for the opposite party. In view of above, list this matter again on 18th of March 2025. The petitioner may also file rejoinder affidavit in the meantime, if so advised.
Deeply obliged.
Yes. Respondent number 3 wanted time.
Lordship, steps to respondent number 3 is still not yet completed.
Respondent number 3.
Yes.
When did you take steps? That was long time back. On steps was taken on 8 June 2023. Since then, nothing has happened. Then, okay, then fresh steps was taken on 24/8/24. Who is respondent number 3?
Private respondent, Lordship.
What is the matter regarding?
Lordship, the matter is regarding the cancellation of government quarter, allotment of government quarter.
Against cancellation of allotment of quota. And who is the respondent number 3?
Respondent number 3 is the one who has been allotted after the cancellation.
I see.
So we may be allowed to take fresh steps on respondent number 3.
How many times you take? Already twice you've taken. Is it possible to give by way of Dasti? Dasti is possible?
Lordship.
Okay, notice. It appears that notice upon respondent number 3 has not been affected till date, despite the fact that steps was taken by the to serve notice by way of registered post with AD due on 2 occasions. Under this circumstance, and as prayed for, petitioner is allowed to serve notice to respondent number 3 by way of Dasti within a period of 10 days from today.
Lordship, interim order is there.
What is the interim order?
Stay of cancellation order, Lordship.
The petitioner shall thereafter file an affidavit as proof to show proof of service. As proof of service. List the matter again after
3 weeks, Lordship.
3 weeks. Stop interim order pass shall continue till the next date of listing.
And you're blessed.
Yes.
Your Lordship, I've been instructed to submit before this court that RSAK is no more the standing council of NIT.
No more the council of NIT.
Yes, standing council of NIT.
NIT.
NIT. So its name may be strike out from this course list.
Then you are for?
I'm for the petitioner.
Sorry?
Petitioner.
You're for the petitioner. Mr. Kato was supposed to take steps for what? No, the
Your Honor,
NIT.
step has been taken, Your Honor.
You've taken steps.
Yes.
How did you take steps? What about Dasti?
Yes.
Dasti, you were asked, you were allowed to take steps in both ways, by usual process and by Dasti. So have you taken Dasti steps?
Yes, yes, Your Honor.
When?
16, 12, 24. Lots of.
You're supposed to file an affidavit.
Yes.
You have not filed an affidavit.
I'm put a petitioner.
Sorry?
I'm put a petitioner. And I have taken step.
No, you are for the petitioner.
Yes.
That we know. Thing is that Mr. Saikia was there for the NIT. Last occasion, somebody said that his term has not been renewed. So court directed you, the petitioner, to take fresh steps by usual process and by Dasti. That means to serve notice to NIT so that they can engage somebody. You say that you have taken steps. How?
So in record 16, 12, 16, 12, 24, it is reported step has been taken to the respondent.
You have not taken steps.
Pardon. Actually, I have not informed. May give some time, Your Lordship.
See, you have already taken the notice memo from the registry for Dasti. You are supposed to file that. Have you served notice or not by Dasti? Steps you have taken, I've seen. Steps you have taken for as per usual service. But regarding Dasti, have you served or not?
Lordship, actually, I have not informed by the leading counsel, judicata.
Okay.
So I don't know exactly what.
Okay. Mr. R. Saikia, learned counsel, is said to be no longer the standing counsel for NIT. Stop as prayed for on his behalf. Name of Mr. R. Saikia be struck off as the counsel for NIT. Petitioner is given a week's time to file the affidavit indicating service of notice to NIT by way of Dasti. Stop office shall also track the postal consignment sent to the respondent NIT and put up a note. List again after a week.
My lord, I am appearing on behalf of petitioner, my lord. Here, my lord, and that is respondent number 4 is supposed to file an affidavit.
You are for the petitioner.
Yes, my lord.
So have you served notice to respondent number 4?
Yes, my lord. I have
When?
taken the steps on 28th of November 2024, my lord. 28 November to 28/11/2024.
There's nothing in the records. See the order dated 28 November. Court's order. You were asked to take steps.
Yes.
You have not taken steps. 28 November, you have not taken any steps.
My lord, in that case, I may be allowed to take and press steps, my lord.
Please write down petitioner to take steps in terms of the court's order dated 28/11/2020. 2024. In terms of the order dated 28/11/2024. No. It also says that unserved notice in respect of respondent number 4 is returned back. Notice. We don't have a correspondence file. How do we trace out the notice? Unserved notice returned back. Where is it? Is that the one? From where you get it? Respondent number, who's respondent number 4? MS Jerkin Enterprise. Is the one. How it has come back? Was it sent at all? Hmm. This respondent number 4 is MS Jerkin Enterprise,
Yes, my lord.
represented by Sri Chukku Takam, resident of Silsango, Sagali, District Papumpare. What is to be done? Can you serve by way of Dasti, or
Yes, my
is it
lord.
possible?
Yes,
Then you cancel the order. Notice served to respondent number 4 by usual process has returned back unserved without any remark. The learned counsel for the petitioner, Mr.
L Tatam, my lord.
L.
Tatam.
Takam.
Tatam.
L. Tatam submits that he may be allowed to serve notice to respondent number 4 by way of Dasti. Stop that. Prayer is allowed as prayed for. How much time should you require?
3 weeks, my lord.
3 weeks for service.
For service, 1 week for service, 1 week.
No.
The resident of this respondent number 4 is at Mangyo, which is
Far away.
far away. Yes,
How much time should you take for that? 2 weeks at least.
2 weeks, my lord.
As prayed for, 2 weeks time is allowed to serve notice to respondent number 4 by way of Dasti through the registry of this court. Place the matter again after 3 weeks.
Much obliged.
26.
Your Lordship, I'm for the petitioner. I'm seeking adjournment on the ground that the leading counsel is out of station, Your Honor. That about the respondent number 5 are also yet to file their affidavit, I suppose.
No, Your Lordship, we have filed, Your Lordship.
Then
We have already filed, Your Lordship.
When?
19/8/24, Your Lordship. It's in
Which respondent?
5.
Pardon, Your Lordship.
Who are the respondents who filed the affidavit? Number
Your
2, 3,
Lordship.
4, 5.
Yes, Your Lordship.
All of them.
Yes, Your 2 to 5, Your Lordship.
You want some time?
Yes.
How much time? For what?
1 week's time, Your Lordship.
For?
To go through their affidavits, especially of the respondent number 5. So
Okay, as prayed for by the learned counsel for the petitioner, a week, the matter stands adjourned for a week.
Your Lordship, a fixed date, maybe.
1 week is fine, sir.
Why fixed date?
There is an
interim with the-
interim, Your Lordship, which is why. After a week, any fixed date, Your Lordship?
When do you want it?
18, Your Lordship. 18.
Cancel the order, please. Cancel the order. The learned counsel, right, like this, the learned counsel for the petitioner submits that
After a week, Your Honor. After a week, without any fixed
he
date.
submits that he has received a copy of the counter affidavit filed by the respondents and prays that he may be given a week's time to go through the same and file a rejoinder affidavit, if so required. Who stop considering the same prayer, let the matter be listed again on
Your Lordship, after a week, without any fixed date. Because the leading counsel comes from the other district, so
listed again on 18th of March, 1 week.
I'm trying, Your Lordship, that the fixed date may not be given. I'll talk with the respondents and then we'll mention the matter.
Yes, after a week, immediately after a week,
Okay.
Your Lordship.
Then what did I say last? List the matter again after a week. Petitioner may file rejoinder affidavit In the meantime, if so advised. All right, interim order passed earlier shall continue till the next date of listing.
Oblige, Your Lordship.
Oblige, Lordship.
Yes, what is this?
My lord, in fact, I was instructed to take instruction, my lord. My lord, in fact, I am engaged counsel here, my lord. This writ petition, it was prepared by one of my associates who is staying there at Alo Western District, my lord. Therefore, my lord, he has done a gross mistake, my lord, inadvertently, my lord. In fact, my lord, in the year 2024, my lord, one writ petition was filed, my lord. That was number is 330 of 2024, my lord. Here in this writ petition, my lord, the petitioner number 2, my lord. He was also one of the aggrieved person, my lord. He in fact was disqualified from this GPM, my lord, Gram Panchayat member, my lord. And in his place, the MLA of the local MLA of the state constituency, my lord, has appointed someone in his place, my lord. So therefore, agreed by his action, my lord, writ petition was filed, which was number 330, my lord, of 2024. And this writ petition was filed, my lord, by 6 petitioner, my lord. 6 petitioner, and all of them has this authorized their one colleague, my lord, who has shown the affidavit, my lord. Now, while my lord taking this authorization letter, my lord, my associate, my lord, who has drafted this writ petition, my lord, he has sought for this 3-4 copies of this authorization letter and got the sign of the petitioner number 2 in this various Okalatnama, my lord. During the pendency of, my lord, this writ petition, my lord, 330 of 2024, my lord, another impugn order was issued by the Deputy Commissioner, my lord. The disqualification initiation, my lord, disqualification proceeding, my lord, culminated into the disqualification of the petitioner, my lord. That order of the Deputy Commissioner was impugned, my lord, in another writ petition, my lord, which is numbered as writ petition number 11 of 2025, my lord. Here, my lord, the mistake, my lord, done by my colleagues, my lord. He has used this authority letter, my lord, signed in the year 2024, signed in the month of November 2024, my lord. What happened, my lord, after filing of this 2024 writ petition, my lord, this writ petitioner number 2, my lord, he died, my lord, but inadvertently, my lord, while filing the fresh writ petition in the year 2025, my lord, he has this given the authority letter, my lord, of 2024, my lord, where the disease petitioner, my lord, he has put his signature, authorizing the person who has the affidavit, my lord.
What are these matters regarding?
This is regarding disqualification from GPM and GPC, my lord.
GBM?
Yes, Gram Panchayat member and Gram Panchayat chairperson, my lord.
Okay. Disqualification?
Yes, ma'am.
And the petitioners are the ones who have been disqualified?
Yes, my lord.
And petition number 2 is no more?
My lord.
Petition number 2 is dead?
Yes, my lord. After the filing of this...
After filing writ petition?
Of
No,
the 2000...
Before.
2004 writ petition, my lord.
My lord, much before even the Deputy Commissioner issued order, the impugned order which is challenged, the petitioner died, my lord. I have, on the last date, my lord, I had placed a copy of the death certificate. My lord, he died, my lord, on 23/11/2024. And the impugned order, my lord, is 2012/2024. Lordship may peruse the last order passed, my lord, 5th of February.
That order was passed, my lord.
No, this petition number 2 died on
On 23rd of November, 2024.
and writ petition filed on
Writ petition filed on 9/1/2025. 9/1/2025.
and the impugn order.
Impugned order is 20/12/2024, 20th December.
His name is also there in the impugn order.
Yes, my, oh, his name, my lord, is not there. Is not there. But he has, his signature is there on the Wakalatnama and the authorization which my learned friend refers to. His signature is there on the authorization itself. And the affidavit is sworn on 4th of January. That my lordship was pleased to direct, my lord, by the order dated 5th February. On the question of maintainability of the writ petition, as well as the second last paragraph therein, my lord.
My lord, it is not disputed that my lord, this writ petition, my lord, the present writ petition, my lord, has been filed after the date of the petitioner number 2, my lord. It has been inadvertently made petitioner. He has it, my lord. That, my lord, for that, my lord, on my behalf and on behalf of my colleagues, my lord, who has wrote this writ petition, my lord, I really express apology, my lord. In fact, my colleagues was told about the demise of this petitioner number 2, my lord, by the petitioner, my lord. In fact, he was told, asked to drop the name of petitioner number 2.
Then,
mistakenly, my lord, he has this.
In fact, my learned friend, my lord, he had informed the petitioners. He also hails from the Aporijo. He had informed the petitioners about this, but they went on with the writ petition.
That is correct, my lord. That we are not disputing, my lord.
That means knowingly you are doing that. It is not that by mistake you've done it.
This, in fact, my
so.
my colleagues had done the mistake. What had happened with him, I don't know, my lord. My lord, I have spoken to him personally, my lord. In fact, he's also not denying that the petitioner had informed him about the demise of the petitioner. But then he is expressing that mistakenly, I have done this, I have done the wrong, my lord. He is also this.
How can it be mistakenly?
That, my lord,
if he is already informed.
That is true, my lord. That for that also I have scolded my colleagues also, my lord. Not only me, even the petitioner, my lord.
So what is
that should not have been done, my lord.
Mr. Kamduk will definitely not do that. He's fair enough. Mr. Kamduk will knowingly not do. But well, maybe the writ petition in the present form will not be maintainable, my lord. And of course, the other aspects are there, which I would not press, my lord. But the other aspects are there.
You take back your writ petition then.
My lord.
You take back your writ petition.
My lord, this writ petition, my lord, I will be taking back writ petition.
Withdraw your writ petition.
Number is writ petition 11 of 2025, my lord.
Because they are all clubbed together, isn't it?
Yes, my lord.
So this respondent number, petition number 2 is there in all the cases?
No, my lord. Not in all the cases. Only in the writ petition number 11, 11 of 2025.
What is his name?
Penjum Bui.
Penjum Bui, my lord.
Penjum Bui.
And in writ petition number 330 of 2024, he is the writ petitioner, my lord. In fact, in this writ petition, my lord, he has given his authority. He was by that time, my lord, alive. But still, my lord, may I pray that I may be allowed to withdraw this about this writ petition. Petition number 330 of 2024 and writ petition number 11 of 2025, my lord.
330?
330, my lord.
Where's 330? There's no 330 here.
330 today, it is not listed, my lord. 11 to listed.
Most probably this one. 627.
No. 627. No, it is not. 11, my lord. 11 is well. My lord, may kindly allow me to withdraw this writ petition number 11 of 2025. Item number 30.
So apart from this petition, number of action subsists for the remaining?
My lord, it will subsist.
Why are they all clubbed together otherwise?
My lord, in fact, the order has been passed by the same deputy commissioner, my lord, although it is passed in different date, my lord.
Similar disqualification.
Similar disqualification,
How
my
many
lord.
persons have been disqualified?
My lord,
In
in
total?
this case, 6, then 6, 12. And
By the same order?
No, different orders.
Different.
Eight,
There,
like 20
my lord, they are from the different segments, my lord.
Why are they clubbed together otherwise?
My lord, similar causes of action.
Similar
Not the
cause-
same, but similar causes.
Similar cause of action, my lord. Notice were issued to all of them. They were represented by one single counsel, my lord. The counsel representing the petitioner, my lord. They,
However, my lord, this WPC 627, that one I'm not sure, my lord. I'm not representing anyone in the WPC 627, item number 28. That there the cause of action may be different.
No, they have the same order.
Same order.
But the expert order.
Oh, expert order.
in repetition number 627, my lord, the government, they were supposed to file affidavit, my lord. They have not yet filed affidavit, my lord. And here there is interim order running in my favor, my lord.
In which case?
In
WPC 627.
WPC 627. Item number
28.
They're all clubbed together, but separate orders have been passed. I don't know why.
Same order. Whatever 25.
Which is the impugn order? Let me see.
My lord, my lord is talking about which petition, my lord.
Yeah, this one, the one which the dead person has been made alive. WPC 11.
WPC 8 of 2020.
11.
Oh, sorry, 11, please. The impugn order, my lord.
Is it page 65?
Yes,
65.
from page 65 order. My lord, the case of the petitioner is dead, my lord. They were GPM and GPC, my lord. With the intervention of the local MLA, my lord, they have been now removed, disqualified by the deputy commissioner, my lord. But, my lord, deputy commissioner, while passing this, issuing this impugn order, my lord, the petitioner were not heard, my lord. In fact, my lord, during the proceeding also, petitioner has sought for the complaint letter, my lord, which was filed by Mandal against the petitioner, my lord. Alleging some
this GPC, GPM, they are from for which area?
This is from, my lord, Tanitator segments, my lord. Nayan Gusar, Jila Parishad, Tanitator segments, my lord. This comes under 26 Dumporojo Assembly Constitution, my lord.
Is it the same deputy commissioner?
Yes, my lord.
Under the same jurisdiction?
Yes, my lord.
Apart Subansari?
Yes, my lord.
All of these cases?
Yes, all these cases, my lord.
How is the area earmarked otherwise? Under the constituency?
Constituency.
Yes.
Different constituency?
Yeah, there is this.
So GPC and GPM of different constituencies? No, of different constituencies?
Yes, my lord.
Have been removed, have been disqualified?
Yes, my lord. There are 4 segments, my lord. 4 Jila Parishad segments, my lord. One is, my lord, Gusar Jila Parishad. Another is Maro Jila Parishad, and there is also other is Gita Riba.
Anyway.
Yes, ma'am.
You withdraw this writ petition and you file afresh if you want to. It cannot go as it is. Petition number 2 has expired. Or we can strike off his name.
Striking out may not be, my lord, because the affidavit is sworn by the one of the petitioners, and the wakalatnama remains. Wakalatnama is the same wakalatnama, my lord.
Mr. Kamduk?
Yes, my lord.
So we'll dispose of this with your withdrawal. You withdraw this writ petition.
Yeah, this writ petition number 11, my lord.
11.
Yes, my lord, may kindly allow me to withdraw with a liberty to file a press, my lord, because
And in respect of the other writ petitions,
there is no defect, my lord, in respect of other this.
now, what are the stages for the other writ petitions? What is the stage?
The stage is, my lord,
Notice was issued, my lord.
notice was issued, and even, my lord, the respondent number 3 and 4 in other writ petitions, my lord, they have filed their wakalatnama, my lord.
And I represent 3 and 4, my lord.
In which case?
My lord, in WPC 8, 10, and 11. The 11 is the one in which my learned friend is.
I don't know why these matters have been all clubbed together like that, you see. This has caused difficulty. You are there for 3 and 4 in all the cases?
No, my lord. In WPC 8, 10, and 11. That item 28, I'm not.
How many cases are clubbed together here?
4, my lord. 3, 4. 8 of 25, 10 of 25, and 11 of 25.
Please write down. Peruse the court's order dated 5/2/2025. Wherein the court has been informed that the petitioner number 2, despite having expired on 23/11/2020, is said to have given the authorization to file the writ petition by signing the wakalatnama.
Lord, don't know, my lord, but if that is reflected in the order, my lord, my friend may have some problem later. It's the plain withdrawal. My lord.
Yes, my lord, with a liberty, my lord. Plain withdrawal with a liberty, my lord.
With apologies, my lord.
Yes, my lord.
I mean, on my part, my lord, for making submission.
But the order remains, isn't it?
Yes, ma'am.
The order remains.
Order remains. Of course, that earlier order is there.
Okay, cancel the order. You write like this, peruse the order dated 5/2/2025. Stop. Mr. D. Kamduk, learned counsel for the petitioner, submits that he may be allowed to withdraw the writ petition with liberty to file afresh. Stop. The said praise not objected to by the counsels for the opposite parties. In view of above, WPC number 11 of 2025 is
Yes,
allowed to
ma'am.
be stands dismissed as withdrawn. Stop. However, liberty is granted to the petitioners to file afresh, if so advised. Then in respect of
In respect of my lord, the service is completed in all other, my lord, writ petition, my lord. So therefore, matter may be fixed for this admission hearing.
28 service complete.
Yes, yes.
28.
Yes, yes. Complete.
20.
This one, this other one. This one, this one.
Yeah. Yes.
Then you write WPC number 11 of 2025 be detached from these bunch of cases. This will be a common order. Then now you submit in the other writ petitions. What is 10, 6 to 7 and 8?
10, 8.
Notice is complete, no other parties in the other writ petitions?
Yes, my lord, I have checked the record, my lord.
8 and 10 is complete, my lord. The 627, I'm not sure, my lord.
627, my lord.
Mr. P.D. Nair, learned counsel, appears for the
3 and 4, my lord.
respondent numbers 3 and 4 in WPC number
8 of 2025 and 10 of 2025.
8 of 2025 and 10 of 2025. Who else?
My lord.
So, respondent 1 and 2.
And-
item number 27 and 29. And in 28, I'll read for 2 and 3.
This
In
great-
8 and 10, my friend is for respondents 1 and 2.
For 27 and 29, I will for 1 and 2. And for item number 28, I will for 2 and 3.
Mr. Nair,
My
you are supposed to file something?
my lord, on admission hearing, we'll
Any
file one
affidavit?
affidavit before the admission hearing. my
You
lord.
have filed.
My
You have not filed, isn't it?
We have not filed, my lord, because this issue was there, my lord.
Mr. Pidina appears for respondent numbers
3 and 4.
3 and 4. In WPC number
8 of 20.
8 of 2025 and 10 of 2025. Miss, your good name? K. Wangmo, learned government advocate. Appears for respondent numbers 1 and 2. Yes. Stop aspirate for how much time? 4 weeks. 4 weeks time is granted for filing counter affidavit to the respondents. Just again after 4 weeks.
My lord, there is interim order in number 28, my lord. That may
The
continue.
problem, we all club things together and item number
28, my lord.
and there's no interim order in others.
No, my lord.
Yet you all club these matters together. Orders are here and there, we don't know.
Yes, my lord, in fact, my lord, I have to admit, my lord, it is only because of our mistake only, my lord. Otherwise, my lord, this matter has been fixed for this hearing on the interim, my lord. Still today, my lord, today it was.
One more line, the interim order passed earlier in WPC number 7 of 2024. Stand extended till the next date of listing.
Deeply obliged.
Much obliged. My lord, can it be fixed next week, my lord? Next week. Okay. Matter, maybe, can the matter be fixed on next
I
week?
said 4 weeks.
4 weeks. Let it be after 2 weeks, my lord, because.
Why?
Because my lord, their tenure is going to be, my lord, completed by this 2025 only, my lord. Only few months has left, my lord. Still they are trying their luck, my lord. In fact, there are some illegalities in this passing this impinging order. That is there.
They wanted 4 weeks, I've given them 4 weeks. Why do you want 4 weeks otherwise?
Get some instruction. Need some instruction.
You take 2 weeks at a time, not straight away 4 weeks. If some extension is required, then you pray again. All right, make it 2 weeks.
Much obliged.
Deeply obliged.